to receive public and government witness testimony regarding these agencies' performances during fiscal year 25 and fiscal year 26 to date. Do I have any colleagues? All right. So with that, we are going to move as expeditiously as we can. I promise you, my voice will remain throughout our hearing. So no stress with that, all right? So we'll get through this. It's a pleasure to have you all here today. And we're going to first start with testimony from our public witnesses. And we'll start with Laura. All right, we're going to start with Laura Fuches, who is president of the Washington Teachers Union. And she is virtual. And then we will hear from, is he here? Yes. Oh, I see. All right. And then we have in-person witnesses, Dr. Kofi Onuma, who is representing AFGE Local 2725, and Joseph Alexander, who is representing Department FOP Labor Committee. And I'm not sure whether it's AFGE or if it's just FOP, but I have that kind of information here, and he will straighten that out for me. So we'll start with Ms. Fuches and then move to Dr. Onuma and then Mr. Alexander, and that's our first panel. So you can take to the witness stand if you are here in person so we can get your testimony. All right, Ms. Fuches?
Yes, thank you. Can you hear me?
Your testimony. Thank you.
Can you hear me? Is the sound working? Hello?
You can begin when you're ready.
Sorry, are you able to hear me? I just can't tell if anyone can hear me. Can you hear me?
Ms. Fuches, we cannot hear you.
My audio is showing that it's...
You check your...
Is your sound on?
Okay, your audio shows is working. Our sound is on.
But you can't hear me?
Just a minute, we're gonna get some technical assistance here. All right, we will have to recess for about 5 minutes. There are technical difficulties here in the building. So just hold on, please. While we are waiting, I recognize that I believe Ms. Aisha Williams is here. If you will take to the witness stand, we'll have you and Mr. Ki Gilman. Mr. Gilman, we'll add you and Joseph Alexander.
Are you able to hear me now?
Yes, we can.
Oh,
thank
good.
you so much. We're back in business.
You. I appreciate it. I really appreciate y'all accommodating me virtually. I had planned to be in person, but that just things happen, as we know. All right, I'll go ahead and get started. So the Office of Labor Relations and Collective Bargaining is fundamentally broken. They view their role as one of maximizing executive power and are willing to waste tax dollars, throw out goodwill through extreme and unfortunately personal disrespect, discard opportunities to collaborate, and defy even the Public Employee Relations Board to do it. In my short time in office as president of the Washington Teachers Union, I've already been met with stonewalling. In August of 2025, the W2 invoked impact and effects bargaining over the district's energy policy. We met and presented a series of proposals to OLRCB. We still have yet to hear back. In July, the W2 won a major arbitration award that gave over 150 educators access to over $2 million. Instead of working with the W2's legal representation to discuss how that would work and ensure that everyone who was owed was made whole, money was dispersed to members with zero documentation, warning, nor communication. This led to member confusion. They didn't know why they were getting paid. Some who thought they may qualify were wondering why they weren't paid, and nobody knew if the amounts were correct, let alone that the DC Retirement Board was paid and other elements of making everyone whole were met. When the W2 requested access to the data to verify that everything was done correctly, OLRCB sent an unusable PDF. When the W2 requested access to usable information, we were ultimately forced to go to the PERB and work it out in mediation. Throughout this, the lack of professionalism displayed by the executive director and attorneys involved through their communication was staggering, although unfortunately not surprising. Throughout W2's negotiations, both the latest and those in the past, and verified by the Public Employee Relations Board after the fact, OLRCB did not negotiate with the W2 in good faith. We have words in the contract that should be easy fixes because they are literally offensive. But the W2 cannot even touch them because OLRCB wants to get rid of any and all protections we have for special education teachers claiming managerial rights. And so the language persists. I have testified repeatedly that for my 18 years teaching in DC public schools, I have spent 12 out of contract. This is a failure of OLRCB. Their lack of interest in actually collaborating and working with our public sector unions, I suppose they view as a strength. But I don't really want to be compared to the worst of the worst union-busting corporations, and I hope the district government doesn't want to either. Finally, OLRCB should be working more with DCPS to ensure that DCPS is following the W2 contract and that they led negotiations over. We have to stop allowing endless lawsuits, appeals, and a ridiculously delayed grievance system to promote a system where administrators have almost zero accountability and end up costing the district millions of wasted dollars in back pay and making our members whole. This is one of the driving factors of high educator turnover and also leads to poorer educational outcomes for our students. The W2 has just in the past few weeks won yet another arbitration that clearly says that DCPS began violating the new provisions negotiated with OLRCB in the contract on day one. In negotiations, DCPS accepted W2's proposals without pushback or further negotiation, a fact they admit in arbitration. They then tried to argue for a year and a half that the plain language that was submitted by the W2 didn't mean what it meant. The arbitrator wasn't hearing it. An example of what they said in their written decision, having carefully reviewed the evidence and arguments advanced by the parties, I find that the clear language of Article 23.17.6.1 requires the payment of an administrative premium to co-teachers who provide instructional coverage for an absent co-teacher. Now DCPS will be required to pay our teachers, and we are going to try and win them back pay for the year and a half of violations that they have now imposed on our members. This is not an isolated incident. This is just how DCPS operates. OLRCB, I would hope, thinks the contracts they negotiate have meaning and would provide legal counsel to their agencies to follow it. Instead, they do the opposite and back agencies into losing corners time and time again, costing the district untold millions and literally ruining lives and careers in the process. Money doesn't make up for all the harm OLRCB and DCPS inflict. I've been the president for 6 months. In my administration, we have filed over 200 grievances through our office since July 1. Those cases are being stuck in a bottleneck that DCPS puts into place on purpose in order to slow down the rate that we can actually hear and resolve these issues, leading again to expensive litigation and arbitration. Unfortunately, I won't be able to take questions today, but I'm happy to schedule another time when I can. But I do really appreciate your accommodating me and allowing me to testify today. Thank you.
Thank you very much for your testimony, and obviously, we will attempt to examine some of what you are sharing today with the office when they are before us a little later. But thank you very much for that.
Yep, I appreciate it. Thank you.
And now we'll move to our public witnesses. Dr. Kofi Onuma, who is representing AFGE Local 2725. And I hope, Dr. Kofi, we're not going to talk about your desire, your need to strike. This is a joke, guys. He and I understand. Mr. Gilman wants to join on that. Okay, please go ahead, sir.
Good morning,
Good
Chairperson
morning.
and members of the Committee on Executive Administration and Labor. Thank you for the opportunity to testify. I'm Dr. Kofi Onuma, First Vice President of AFGE Local 2725, here representing DC public employees. Today, I want to be crystal clear. The current dispute resolution system is broken. Under the Compensation Merit Personnel Act, members must exhaust multiple grievance steps and then proceed to arbitration when agencies fail to bargain in good faith. Yet, the board created without labor's involvement and the office charged with representing management are woefully under-resourced and structurally imbalanced. The Office of Labor Relations and Collective Bargaining, OLRCB, serves as the principal management advocate in labor relations matters, representing agencies in negotiations, arbitration, and before the Public Employee Relations Board. It is housed within the mayor's executive office and does not process grievances on behalf of employees. Rather, it advocates for management's interest. The Public Employee Relations Board, PERB, is the only forum in DC where DC public employees and unions can seek neutral adjudication of unfair labor practices, grievances appealed for arbitrations, awards, impasse, disputes, and negotiability issues. It is a 5-member board appointed by the mayor with DC council consent, meaning the entity that manages the agencies also appoints the judges who must rule on disputes involving those same agencies. PERB's budget remains small. Its fiscal year 2025 approved budget shows no real growth despite growing caseloads. There is limited staffing to facilitate settlements, mediation, or hearing capacity. That lack of capacity creates bottlenecks. Only an infinite number of arbitrations can be scheduled at a time, which means cases languish for months or years, delaying justice. Mediation is limited because there are too few personnel to assist the parties. Grievances that should be resolved quickly end up backlogged, leaving workers without timely access to fairness in contract enforcement. And make no mistake, grievances and arbitration processes are not cheap. They are legal matters requiring legal expertise. Unless our unions have lawyers on staff, fiscal reality dictates that we must hire counsel. In my experience, a single grievance through arbitration, including investigations, transcripts, filings, and representation, can range roughly from $15,000 up to $50,000. Justice should not be contingent on a union's bank account, yet in DC, it absolutely is. Not all unions have a war chest. Some operate with minimum budgets. When arbitration becomes financially unreachable, the grievance stage becomes the only realistic remedy, even when arbitration is the just outcome. Part of the problem is that management retains rights that employees do not. We have seen in past years agencies' reorganization and reduction in force implemented without meaningful impacts in effect bargaining, resulting in layoffs, closures, and workforce disruptions, actions that profoundly change employment conditions. Yet when labor seeks to enforce good faith bargaining or meaningful remedies, the system moves slowly and too sparsely resourced. That's not oversight. That is structural design. It is also concerning that PERB judges are appointed without labor's involvement in the appointment or vetting process, while they preside over disputes involving very management that appoints them. This raises concerns about perceived impartiality in a system where management already holds significant leverage. I acknowledge that today's hearing might not be the direct forum for policy prescriptions, yet I have submitted proposals to the chair that would enhance this committee's oversight, requiring agencies to testify more frequently and to be held accountable for bargaining performance. And I have yet to receive a response. As I sit here today, I ask, is the system working as intended, or is its brokenness simply not acknowledged until now? This committee has the power to level the playing field, to ensure timely resolutions of disputes, equitable access to arbitration, and fairness in collective bargaining enforcement. Doing it will not only improve labor management relations, but will translate into better government services, higher workplace morale, and lower taxpayer costs associated with protracted disputes and turnover. Thank you for hearing this testimony. I sit ready to answer your questions. Thank you.
Thank you very much for your testimony. And now we'll hear from Mr. Alexander. Thank you.
Good morning, Chairperson.
Now you're on. Thank you.
Okay. Good morning, Chairperson, Bonds, and Council members. Thank you for the opportunity to speak today. My name is Joseph Alexander, and I'm the Sergeant with the DC Department of Corrections and the elected chairman of the Fraternal Order of Police Department of Corrections Labor Committee. I'm here today because actions taken over the past 2 years have deeply shaken employee confidence in the system that is supposed to protect their right to choose representation. In this history, the Public Employees Relations Board has never unilaterally decertified a union as a remedy in the standards of conduct case, a case that the union remedied in accordance with its bylaws before the complaint was lodged with PERB. That changed here with the decertification of the DC DOC FOP Labor Committee. Under PERB's own rules, decertification occurs through employee action. It requires a petition from the membership and a vote. It is not listed as a remedy for a standards of conduct complaint. In this case, no petition was filed, no employees asked for a decertification. Even the complainants who filed the standards of conduct complaint did not request decertification as a remedy, yet PERB imposed it anyway. That single decision immediately nullified a collective bargaining agreement governing safety, staffing, discipline, and working conditions for nearly 1,000 public employees. The consequences were immediate and real. Employees lost hard-fought protections, supervisors lost the structure framework for resolving disputes, morale declined, tensions increased, and inside correctional facilities, instability is not theoretical. It affects staff, management, inmates, and ultimately public safety. This action also disqualified 1,000 employees from bargaining representation and ongoing Comp 1 and 2 negotiations that are currently taking place. We also face record numbers of assaults on officers daily, with most severe officers being stabbed and assaulted with feces with no collective avenue to address these concerns due to a nullified working conditions contract. What followed next was equally unprecedented. Unprecedented. PERB conducted a representation election. It oversaw the process. It counted the ballots. The election produced a clear outcome in which FOP had the clear majority of employees' votes. And yet, instead of certifying the results, PERB later ordered that same election to be rerun. To our knowledge, that has never happened before in PERB's history. That matters because elections are supposed to be the remedy. When confidence is questioned, employees vote. When accountability is needed, employees decide. That is how the system is designed to function. Decertification exists for one reason. So employees, not agencies, can remove a union if they choose. And if employees make that choice, they retain the power to put that union right back. That safeguard is critical. When an agency takes that authority upon itself, it undermines the foundation of representation law. If this overreach is left uncorrected, then no union in the district is safe. Any labor organization could be stripped of representation without a petition, without a vote, without the consent of the people it serves. That should concern everyone. This issue goes beyond the FOP. It goes beyond corrections. It speaks to whether the public employees in this city can trust that the rules will be applied as written and that their collective voice will be respected. when that same agency that imposed an unprecedented decertification also controls whether an election is certified, delayed, or rerun, it creates an unavoidable appearance problem. The question becomes not just whether procedures were followed, but whether employees can reasonably trust the process itself. Oversight exists precisely for situations like this. Our members continue to show up every day and perform one of the most difficult and dangerous jobs in public service. The FOP continues to stand with them. Our legal defense plan remains active. Our commitment to representation has not wavered, but resilience should not be mistaken as silence. We respectfully ask this council to examine whether PERB exceeded its authority, whether remedies outside its rules were imposed, and whether employee choice has been respected or overridden. The choice of union representation belongs to the employees. It always has, it always should. Thank you for your time, and I'm prepared to answer any questions you may have.
Thank you very much for your testimony as well. And now, Ms. Williams, we'll hear from you. Thank you very much for being here.
Thank you.
Mhm.
Madam Chairperson Bonds and members of the Committee on Executive Administration and Labor, thank you for the opportunity to be here today. My name is Aisha Williams, and I serve as president of AFGE Local 2978. I represent employees at the DC Department of Health and the Department of Energy and Environment, public servants who work every day to protect the health, safety, and environment of the district's residents. These employees show up day in and day out for the district. But when their workplace rights are violated, whether through unsafe working conditions, unfair compensation, improper hiring and rehiring, harassment, or retaliation, they have limited avenues for recourse. Primarily, those avenues are the Public Employee Relations Board, known as PERB, and the Office of Labor Relations and Collective Bargaining, or OLRCB. I want to be clear. This is not about the dedication of staff within those offices. I see a lot of familiar faces. It is about the structure itself. PERB's board members are mayoral appointees, and OLRCB represents the mayor and district agencies in disputes against unions. That structure creates, at the very least, an imbalance that our members are forced to utilize. Then there is the issue of time. Our members regularly ask us for updates on cases that have been pending for months, sometimes years. During that time, they are still working under the very conditions they challenged. Delays are not neutral. They weigh heavily on employees who are simply seeking fairness. And finally, we are also seeing a pattern in impacts and effects bargaining. While OLRCB is required to bargain in good faith over changes to working conditions, too often are those changes appear to be decided before the union even reaches the table. When bargaining feels like a formality instead of a genuine opportunity to shape outcomes, trust in the process breaks down. For these reasons, we are asking this committee to take a serious look at the framework, the timelines, and the processes governing labor relations in the district. Our members deserve a system that is balanced, timely, and truly fair. AFGE Local 278 thanks you for the opportunity to present our testimony today. I'll yield time. Thank you.
Thank you. Thank you very much for your testimony. And then finally, we'll have an opportunity to hear from Mr. Ki Gilman, who is president of AFGE 2725.
Good morning, Chairperson Bonds and members of the committee. My name is Ki Gilman, and I serve as the president of AFGE Local 2725. I am here today because the district's labor structure, specifically the Office of Labor Relations and Collective Bargaining and the Public Employee Relations Board, is not operating with the balance, urgency, or accountability that district workers deserve. Let me be clear. When agencies violate collective bargaining agreements, delay or refuse to bargain in good faith, or fail to implement arbitration awards, there must be timely consequences. That consistency is currently lacking. I also want to address a matter of accuracy. During the past oversight hearing before this committee on December 12, 2024, a staff member from Director Maxwell's office stated that he meets with labor leaders regularly for coffee. That statement as it relates to me and my local was false. I have never sat down for a coffee meeting with Director Maxwell. In fact, I have never met him in person. At the same time, Director Maxwell has repeatedly reached out to At the same time, Director Maxwell has repeatedly reached out to national representatives of the labor organization with whom I'm affiliated with, rather than engaging directly with the elected leadership of the local that represents district employees. That's a violation of DC official code. Constructive labor management relations require direct engagement with the individuals accountable to the workforce here in the district. That the record should reflect that distinction. Beyond that, Director Maxwell does not appear to lead his office in a manner that reflects effective labor management coordination. It has become routine that when labor attempts to coordinate with its staff to strike for arbitrators or to schedule arbitration dates, unnecessary delays occur. These are not isolated incidents. Communication stalls, responses are slow, scheduling becomes protracted, and there is rarely a clear or reasonable explanation provided. When arbitration scheduling, something that should be procedural and straightforward repeatedly slows without documented justification. It raises serious concerns about whether delays have been a practice rather than an exception. Arbitration is the enforcement mechanism of collective bargaining agreements. When arbitrator striking and scheduling are delayed, enforcement is delayed. And when enforcement is delayed, contract rights are weakened. At PERB, timeliness remains a serious concern. Hearings must be scheduled promptly and decisions must be issued within reasonable timeframes. When unfair labor practice complaints or representation matters linger for extended periods without timely hearings or decisions, the practical effect is that the underlying violations continue unresolved. There is also a larger accountability issue. When PERB finds that an agency has violated the unfair labor practice statute, where is the individual accountability? If I, as a district employee, violate the law and it is adjudicated that I committed the violation, discipline will follow without hesitation. Yet when PERB upholds findings that an agency has violated the law, agency directors are not disciplined for those infractions. If violations of statute carry no leadership consequences, then enforcement becomes symbolic rather than corrective. Oversight should examine measurable outcomes. How long a case is pending before PERB? How long does it take to strike for an arbitrator? How long from grievance advancement to hearing date? How many arbitrations awards remain unimplemented? And when violations of the unfair labor practice statute are found, what corrective or disciplinary measures follow? Those numbers will provide clarity. This is not about confrontation. It is about enforcement and credibility. If the district expects employees to meet deadlines and comply with the law, agency and agency heads must be held to that same standard. Chairperson Barnes and members of the committee, labor oversight must be grounded in accuracy, direct engagement, timely enforcement, and real accountability. District workers deserve a system that operates transparently and honors both statutory rights and negotiated agreements. I stand ready to work with the committee to strengthen accountability and restore confidence in the district's labor oversight framework. I'm available for questions if needed. Thank you.
Thank you very much for your testimony from our public witnesses. I really, can you please, I think the FOP has about 1,000 employees, am I correct, Mr. Alexander? Okay. And for Ms. Williams, for your 2978, what count do we get?
160.
460. And most of them are with the Department of Health?
Yes.
Okay. And Mr. Gilman, how many are we for your union?
Approximately 1,300.
1,300. All right, this helps me to get a handle on what we're trying to deal with. And when I say that, I mean, we're talking about trust. We're talking about, from my perspective, as one of the legislators responsible for assigning our dollars and cents to programs, we're talking about a lion's share of our cost in order to do business as a government. So we certainly want to make sure that what we do is not just fair and that the employees can trust management, but we want to make sure that we have a mechanism in place, as you mentioned, Mr. Gilliam, where if there's a delay, what's the cause of the delay? And it does cost all of us money when we have a delay. More importantly, if management is to take a particular, to move in a different direction, we'd like to have them to move in a different direction as well. This is a two-way street. That's what I'm hearing this morning, that the rights of our employees are as valuable as the rights of our management system. And so I will try my best to examine some of what you shared with me today with the two labor organizations when they are before us. You have that commitment. Now, being a child of the 70s, I think I'm hearing that we might need to make some changes in the processes that we have. And so we're going to have to work together in order to bring that about. As you know, we will have a new administration next year. And usually with administrations, they have their own way of doing things. But one thing we can do this year is to make sure that we have fairness in our process. I'm hearing that some of our agencies are not as timely in their decision making as they need to be, so we can work on that. And I'm also hearing that it's very difficult for our employees to trust that management makes the rules, management does the review, and management makes the decision. And you'd like to have, I think I'm hearing that you'd like to have a few more seats at the table so that you have a sense of justice for your members. Am I on target, Mr. Gilliam?
Well, Chairperson, I want to give you an example because you mentioned management rights and employment rights. I got a situation ongoing right now at one of my agencies I represent. Employees at the DCHA, and they're an independent agency, but they still fall under the under PERB. And I'm gonna give you an example about management rights. Since the middle of January, my members in a certain division in the agency are dealing with a rat infestation. They actually work in an environment where rats are just traversing throughout the building. So of course, what I did was filed a grievance. I did everything in my power. I contacted another agency to do an inspection. I contacted the media. I spoke with the agency director. The problem is still ongoing. I want to give you the example why management rights and employment rights are so unbalanced. Me putting the grievance in, as you know, it can go to arbitration, but arbitration with these delays, that's not going to stop people they still coming in the office with rats inside the office. What happened was a member of the public that they service was in the building last week and actually had to jump on the table to escape a rat. So I hit my shop steward sent me a picture. I blurred her face out and I sent it to the director. Director closed the building down. They don't care nothing about staff. All they worrying about is the public. That's why they so unbalanced. And from a labor perspective, now what I gotta do is go to arbitration, but they're still in there working in there. I got a picture when I was on the way here of a rat actually just going through their drawers. That's something where we have to create an equal setting with management rights and employment rights. I wanted to give you that example because it's highly frustrating.
I appreciate that's a very good example, and I think I can follow it along from grievance to where you feel it should be into arbitration. But sounds to me like we need to get that done immediately. That building needs to be fixed, and we should not have employees in that circumstance.
You're exactly right, but I mean that's one instance that's recent. But I mean this happens daily throughout the government.
Yeah.
Thank you.
Yeah, that I appreciate that. That's a good example of when you talk about grievances. So it's not, sometimes it's just ordinary situations that no one should have to encounter. I appreciate that. Any other, Ms. Williams, you have an example?
Oh, yes. So with this structure, I talked about timelines. In your chambers last year, we spoke about a case that had gone on for 7 years at the time, now 8. Those members that were impacted were just made whole this month. So a case going for 8 years plus and having to not have, the situation rectified or reaching a final determination is just unacceptable. So that is just, again, as my counterparts mentioned, just one of many cases.
Well, then may I ask, is it that the case was extended over years because maybe you were in court and that process seems to take a very long time?
My apologies. Yes, it went through various, went through the courts, came back to OLRCB, et cetera, sat in OLRCB for quite some time, going back and forth with our attorneys. However, in our view, it's just another delay tactic that should have been resolved. The administrative law judge had already made a decision, yet it was drawn out even longer than necessary.
And so you feel that the agency purposefully made the case delayed?
I suspect that, yes.
No proof?
We can get some investigators to look into their records, but.
I
Yes.
hear you. I hear you. We will speak with the agency in a very few minutes and we'll ask them about it. Thank you very much. Mr. Alexander, if I understand your situation that you're most concerned with is you're very confused as to why PERB has taken the action that it did, because I think you told me you consider it an overreach of management where they oversaw the election and they counted the ballots. And then with the outcome, they decided to rule that you needed to have another election.
So I want to go back a little bit,
Okay.
councilperson. So first, there was an unprecedented decertification that was not employee driven. And this is PERB's own rules that a decertification is initiated with an employee petition and not a unilateral action by PERB. So that was an overstep. So afterwards, PERB scheduled and conducted an election, oversaw that election, and refused to certify the election that they conducted, which was another unprecedented action. And I believe in coincidences, but not that many within a few months. And now we have 1,000 employees that have been without a working conditions contract for over a year. So there are no rules of engagement. There are no balance of power. And this is a action that PERB caused itself. And this is not for the city council to just undo it, but just investigate to see, did they operate within their own rules? That is our issue, because every day, 1,000 employees are suffering because of an action by PERB, and they disregarded employee choice.
Well, I appreciate that, but I too am concerned that you have 1,000 organized employees that are without representation. So let's see if we can examine that with the powers that be that come from the agencies a little bit today.
We would definitely appreciate that.
All
And
right.
I'm one of those workers, so I have firsthand experience.
All right, I appreciate that. Thank you. Thank you very much. And Dr. Onuma,
Yeah, I was hoping you weren't going to leave me out.
no, you and I talk a lot.
Yeah, yeah. Before we move on, I just want to put on the record that a concrete operational proposal has already been submitted to this committee. That proposal is entitled the Good Faith Bargaining Dispute Transparency and Cost Accountability Act of 2026. This proposal does three practical things. It requires agency-level dispute transparency reporting. It establishes objective thresholds that trigger corrective action plans when escalation patterns are excessive. And it aligns incentives by introducing cost accountability for agencies that repeatedly allow disputes to spiral. This isn't an ideological proposal, it is structural oversight. We've been asking for change, we've been reaching out with proposals, and we've been wanting to collaborate. If this proposal is too ambitious, you know that I've proposed more ambitious proposals.
Yes.
Yes. So we're continuing to be engaged with the process, but I want to move away from treating symptoms and actually treat root causes to make a better labor management relation for the District of Columbia public employees and the people we serve. Thank you.
Well, I appreciate that very, very much. And as I mentioned, we have two of the labor organizations with us today. They will be testifying. And I'm not sure what my boundaries are. But it does seem to me that I'm hearing that the delays, we need to address that. And the issue of employees feeling that management controls the entire deck of cards, so to speak. We need to take a look at that. This is the year 2026. The home rule government in which we exist is more than 50 years old now. And I think it's time to take a look at this. Now, not being a labor lawyer, I don't know exactly what can be done, but I can tell you as a member of this community, I'm hearing you loud and clear. And I know that, you know, every now and then, the processes that we have in place need a little tweaking. So let's see if we can't get to that. Certainly addressing again the delays in the grievance process and some of the hard and fast rules that we have on the books as it relates to how do we build trust with our employees, because that's very important today. So I thank you very, very much. Is Ms. Fuchs still on? Okay. All right. So thank you all very, very much. And we'll be talking with management, as they call themselves, as you are calling them, with the agencies very shortly. Ms. Wilcox, I understand you're here with us. We'd like you to take to the testimony table, please. And thank you for being here today. And you can proceed with your testimony when you're ready.
Sure. So I don't have a speech. I've been before the council numerous times regarding these same issues. I am just here today for answers. Everything that this previous panel just spoke of, it's happening at my agency. And that is the Office of the Attorney General. It is very difficult working for OAG because they are attorneys and they're very savvy. They're the biggest bullies around. And we are being subjected to hostile work environments. Everything Ms. Williams just said is so relatable. I have been a victim of the bullying. DC puts in procedures and laws and regulations for anti-bullying. You put in procedures and laws for whistleblowing. And when you file grievances or you file something under these protections, they go out the window. It's like a joke to the Office of the Attorney General because they are very savvy. Everybody knows how great Mr. Swab is with winning cases. We know how great the agency is. I don't take that from them. But we receive the same thing when it comes down to filing disputes within that agency. Personally, I've written letters to the council regarding my situation. I am now a shop steward for ASME 2401, and I am witnessing my colleagues go through the exact same thing that I went through. It is very heartbreaking to see people break down crying because they are being subjected to retaliation and hostile work environments. It has to stop. The PIP process is being used in a punitive manner rather than a corrective manner. They are writing PIPs any kind of way they want to write them. They're doing performance evaluations any kind of way, and it appears to be rampant throughout DC government because there's no oversight. We need additional things to be put in place for employees because we have rights as well. I do not work for the Office of the Attorney General. I work for the people of the District of Columbia. We elect people into the office, and it is the residents of the district that we are working for. I have been told by the labor management person at OAG, the representative, that his role is to protect the agency. So when you tell me that your role is to protect the agency and not the residents of the District of Columbia, or to be biased in this process, it sends a strong message and it shouldn't happen. But we definitely need more oversight. We need the council to look into this PIP process that is going on at my agency and throughout DC government, because it is very, very difficult to work in circumstances like this. And it's hard to maintain a mental capacity to do work that requires you to be error-free when you're under stress and duress all the time. So that's just what I wanted to say today. I have been asking for a roundtable. I would like to sit down with the council so that I can show you multiple examples of what I'm talking about, multiple things that are happening in my agency that are it's a disadvantage to the residents as well as the employees.
All right, I hear you, your idea of a roundtable, but we certainly can have a meeting, and we can take a look at, your file of grievances, and from the perspective of being a shop steward, I think that would be very helpful. You mentioned the PIP, is that PIP?
Yes, performance improvement plan.
Okay, that's what I thought.
And so the performance improvement plan is supposed to be a coaching mechanism to help employees get back on track. However, it's being used to terminate employees. It's just running rampant in my agency. Myself, I was placed on one bogusly. I have documents that I submitted to you guys from Mr. Mancini, where Mr. Mancini agreed, and he is the person who is over performance management in DCHR, DC government. He's over performance management, and he stated to me in these documents, yes, it was wrong for them to place me on a PIP and transfer me at the same time. Yet nothing happened. Nothing has happened. I've been before the council testifying here, before Brooke Pinto for the past 3 years. And it's not a good thing. It's not a good thing. And again, now I'm watching my colleagues experience the same thing.
I think what we have to do immediately is to see if we can get some relief
Yes.
in this situation. I don't know the particulars. It's very difficult to discuss this kind of situation, in public, and that's why I'm thinking, I'm very happy to meet with you, but I must say, you are in the government. We all are in the government. And while we work for the city, the residents, where we would not have a government if we didn't have the residents and the businesses and the organizations that are in our city. But when you work for the government, you're working for that entity. And so the gentleman who told you that
He's the labor relations,
that his role is to protect the government.
to protect the agency.
Yes, yeah. So that seems to be the general feeling about management. That's what I've heard today. And we have to also make sure that it's a partnership, management and the employees. So,
Absolutely.
like I said, might need a little tweaking of the processes that we have. I'm really excited to talk to PERB and the labor collective bargaining office in a few minutes, because they will tell me what my boundaries are from their perspective, and then we'll see how we can proceed. But I'm thinking if it's possible, we may end up with a working group to take a look at labor law and how we apply it in our government today.
Yes,
So I thank you
it's
for that.
very urgent, and I hope this is something that can take place in the very, very near future.
Yes.
Because people are suffering. People are suffering mentally, emotionally. And if you look at your paid family medical leave, you will see more people are taking paid family leave under mental and emotional stress.
Yeah, I see.
It's very difficult.
All right, this is going to be a real balancing act. I can hardly wait to hear what the agencies say, because they have to safeguard the whole process. So thank you very, very much.
And
for your
thank you so much. I
testimony.
really
Thank you.
appreciate it, Council
Thank
Chair.
you. Okay, we're done? All right. Well, that concludes our public witnesses for this morning, and we'll move expeditiously to our government witnesses. We have Mr. Lindsay Maxwell, who is the Director of the Office of Labor Relations and Collective Bargaining, and Mr. Royal Sims, who is the Director of the Public Employee Relations Board. And we will call up, okay. We'll call up the Director of the Department of Employment Services. I don't see her here yet, but I'm sure she'll be in momentarily. We'll take her at the next round. Yes, please. Thank you very much. And thank you all for being here. And I know you're the management table. We're happy you're here. You're part of this government too, so I want to get your testimony as well. And so, Mr. Maxwell, we'll start with you, but let's first swear you all in. If you would raise your right hand. Do you swear and affirm that the statements you make before us today to be truthful and complete? Thank you. Thank you very much.
Good morning, Chairperson Bonds, members of the Committee on Executive Administration and Labor, and staff. My name is E. Lindsey Maxwell II, and I'm honored to serve the residents of the District of Columbia as the Director of the Office of Labor Relations and Collective Bargaining, also referred to as OLRCB. Thank you for this opportunity to testify on OLRCB's performance and activities during fiscal year 2025 and the first quarter of fiscal year 2026. OLRCB is organized into 3 units: negotiations and contract administration, litigation, and administrative support. The Negotiations and Contract Administration Unit is responsible for negotiating collective bargaining agreements, or CBAs, the process by which wages, benefits, and other terms and conditions of employment for unionized employees are established, training management representatives on labor law and policy and the provisions of each working conditions CBA as applicable to their respective agencies, and conducting impact and effects bargaining over subjects that are statutorily deemed management rights. OLRCB's litigation unit is focused on initiating, prosecuting, defending, and monitoring a wide range of litigation activity for and on behalf of agencies under the personal authority of the mayor. This litigation activity consists primarily of grievance arbitrations, unfair labor practice complaints, enforcement actions, and arbitration review requests before the Public Employee Relations Board, or PERB. Litigation activity also flows from interest arbitrations, negotiability appeals, and similar actions that directly arise from the negotiation activities carried out by OLRCB. The administrative unit is responsible for providing general agency support and conducting research and analysis necessary to support management's position during negotiations and litigations. This unit also supports training to agencies regarding the labor relations program and the legal obligations which emanate from DC law, policies, and CBAs. It is also responsible for supporting the negotiation and litigation units, providing human resources, contracting and procurement, and other related customer and operational services for the agency. Finally, this unit also supports the Negotiated Employee Assistance Home Purchase Program, or NEHAP, which assists unionized district employees seeking to buy homes within the district with closing costs and down payments. OLRCB partners with the Department of Housing and Community Development and the Greater Washington Urban League to assist with administering the program to eligible unionized employees. In FY25 and 26 to date, OLRCB staff includes 20 full-time equivalent positions, or FTEs. Of these positions, 11 are attorneys, 8 are for administrative support, and 1 is for the director. Attorneys are directly involved in carrying out the primary mission of the office by providing advice, counsel, and representation to agencies on all matters concerning labor relations. In addition, attorneys actively negotiate CBAs with representatives of the various labor organizations representing district government employees, and they litigate matters across from the unions and on behalf of the executive. The administrative staff supports the director and attorneys and assists in carrying out the office's customer service and other district mandates. Their role is critical in the office's ability to administrate an efficient labor relations programs, as they are often the first point of contact with the employees, management, and labor representatives with whom we interact daily. The District of Columbia's government's unionized workforce represents approximately 27,000 people, or 75% of its employees. In that regard, OLRCB serves as the executive's principal management advocate in administering the district government's labor relations program for agencies under the mayor's personnel authority by negotiating CBAs and representing management in related labor litigation. It is my sincere belief that positive employee and labor relations is essential to creating a healthy and productive work environment. This is why OLRCB's approach to administering the labor relations program is to do so in a manner that embraces efficiency of government operations while also recognizing and respecting employee rights. In FY25, we continue our tradition of regularly meeting and engaging with labor leaders to discuss and develop consensus on a broad range of topics. OLRCB maintains an open door policy with direct lines of communication between local labor presidents and me to facilitate a collective approach when addressing labor relations matters in the District of Columbia. For example, contrary to what you've heard earlier, I continue to have individual meetings with labor leaders, as we call them coffees with the director. These informal meetings are held in my office and are designed to address labor's concerns, communicate the mayor's and/or the city administrator's initiatives and sentiments, and jointly collaborate on problem solving as necessary. OLRCB has also partnered with the DC Department of Human Resources to engage management and labor through site visits at different agencies under the mayor's personnel authority. We use these site visits to educate the executive teams and upper management and the local union leaders with members at that agency on labor and employment relations. We also carve out time to meet separately, OLRCB with the union leaders, to discuss agency-specific concerns and areas for conciliation. I believe these opportunities to roll up our sleeves and sit side by side with our labor partners advance productive relationships with them. Because collective bargaining compensation agreements are by law effective for a minimum of 3 years, the work of the negotiations section is cyclical in nature, assuming contracts are reopened, negotiated, completed, and implemented as expected. This often results in either a period of numerous completed contracts for a period where the majority of our contracts are simultaneously being renegotiated, approved, and implemented on schedule. OLRCB administers and negotiates 25 separate compensation agreements. I'm pleased to announce that during FY25, OLRCB negotiated the successor CBA between the Metropolitan Police Department and the Fraternal Order of Police. This disciplined approach proved especially important as much of this negotiation cycle unfolded during the district's FY25 budget freeze, which required heightened fiscal coordination and restraint. In that environment, OLRCB ensured that bargaining strategies remained aligned with budget realities, structured agreements responsibly, and conserved district resources while preserving labor stability and operational continuity. The past year's work with the unions is evidence of the mayor's continued commitment to the district workforce to provide first-class compensation and benefits to its employees. Litigation resources in OLRCB are used in 3 major areas: arbitration, unfair labor practice cases, and representation issues before PERB. The litigation of arbitrations and unfair labor practice complaints consumes the bulk of OLRCB's litigation resources. Each attorney in the office carries a litigation caseload and is responsible for all related investigations, pleadings, hearings, evidentiary matters, and appeals to the PERB. From the mayor and the city administrator to agency leadership, district government management recognizes the importance of continued learning opportunities in labor law and policy and building and maintaining positive and at times collaborative relationships with labor. In FY24, OLRCB began to increase and expand labor training we provided to district management employees. That momentum continued in FY25 with a measurable increase in both the number of sessions offered and the number of participants served. During FY25, we facilitated training sessions that provided labor law and policy information, best practices, and practical guidance to more than 200 management, supervisory, and executive suite district government employees. In addition, in these sessions, OLRCB continues to host quarterly labor liaison forums where we workshop common labor management challenges and provide guidance on emerging trends affecting agencies across the district. These forums create a space for proactive problem solving and allow agencies to address recurring issues before they escalate into formal disputes. In FY25, we also facilitated labor relations trainings focused on managing in a unionized environment, progressive discipline, understanding Douglas factors, and Weingarten rights, equipping managers with the tools necessary to address performance and conduct issues lawfully, confidentially, and consistently. In FY26 and beyond, OLRCB is focused on refining and optimizing its internal processes and systems to ensure we continue delivering efficient, consistent, and strategic representation to government agencies. As the complexity of labor negotiations and litigation increases, we are committed to strengthening our infrastructure so that our service delivery remains responsive and forward-looking. Our long-term objective is to position OLRCB as the district government's premier labor and employment legal resource, operating with the specialization, agility, and strategic depth of a boutique labor practice within government. In closing, as we continue to provide high-quality legal services to district government agencies, OLRCB's well-known proactive and collaborative approach in working with our labor partners will remain a constant. This level of collaboration with labor speaks volumes to the unyielding effort that we have put into this work. It is my belief that our ongoing investment in strengthening and renewing trust with our labor partners will continue to pay off in FY26 and beyond in ways that we can all be proud of. Thank you for the opportunity to testify today, and I'm eager to answer any questions that you may have.
Thank you very much for your testimony. Mr. Sims, we'll hear your testimony now from PERB.
Thank you. Good morning, Chairperson Bonds and members of the committee. I'm Royale Sims, Executive Director of the Public Employee Relations Board, also known as PERB. I want to begin by taking a moment of personal privilege. Chairperson Bonds, I need to acknowledge that you have been a consistent, thoughtful steward of the district labor relations and the workers and the agencies whose lives intersect with this committee. And we have all been well served by your attention and advocacy. So thank you. Now, before I get into the numbers and data, I want to share a story about why PERB's work matters. Not long ago, a district employee came to our office, unrepresented, uncertain of their rights, and unsure where to turn. Our team sat with them. They walked them through the filing process, explained to them what to expect, and answered their questions. And this wasn't a special case. It's what our team does at PERB every day. That person filed their claim, their concern was heard, and that is PERB's work. Making sure that district labor relations system is accessible, fair, and functional for employees, for agencies, and for the public. And that's what I want you to leave with understanding today. Let me start with who we are. As you know, PERB was established in 1979 as a part of the Comprehensive Merit Personnel Act. Legislation enacted to create a modern, flexible, and comprehensive system of public personnel administration for the district. Within that system, the council established PERB as the agency responsible for implementing a public policy of effective collective bargaining that improves the morale of employees and the quality of services to the public. We are an independent, quasi-judicial agency led by a multi-member board of labor relations experts. One member is designated as a labor representative, appointed from labor. One member is designated as the management representative, and 3 members are public representatives. And the chairperson of our board is a member from the public seat. Currently, our board has 4 members with 1 seat vacant. That independence is foundational to everything we do. We can only be trusted as a neutral arbiter if we are in fact neutral. Our mission is narrow but essential, and PERB has held steadfastly to it, driving collaboration and process improvements with a consistent focus on a more effective labor relations outcome for the district. Now, let me tell you what that looked like in practice. When I took over as executive director, PERB was managing a significant and sustained increase in caseload. In FY23, we opened 35 cases. In FY24, that number jumped to 101 cases. In FY25, we opened 65 cases. And in the first quarter of this year alone, we have opened 44 cases. Increased case volume is not a temporary spike. It is an enduring trend, and we have structured our workflows accordingly. And throughout this growth, PERB has remained focused on efficiently processing cases while 1, safeguarding parties' access, 2, maintaining a record of well-reasoned decision, and finally upholding our core values of neutrality and fairness in all of our proceedings. As executive director, one of my top priorities was to make sure that we were organized to meet this moment. That's why in FY25, we created a chief of staff position, a new strategic leadership role to coordinate our operations across budget, personnel, procurement, and technology. We also restructured our reporting lines to improve accountability and efficiency. These weren't cosmetic changes. They were investments in our capacity to deliver. And I'm pleased to report that PERB has just hired our 7th attorney, bringing us to 7 of our 8 positions full. And we expect to recruit that 8th attorney before the end of this quarter. We have also been innovating where we can. One example, PERB identified a challenge that our colleagues at the Office of Labor Relations and Collective Bargaining were facing. they weren't receiving timely notice of new cases when they were filed from their clients. The delays meant additional filings. Additional filings meant slower resolution. We fixed that. We implemented a new notification process, and the results have been meaningful savings in time and resources for everyone involved. That kind of proactive collaboration is what I want this agency to be known for. We also brought our own website, calendar management, in-house. A small change that has improved accuracy and timeliness in how we communicate to the public we serve. I want to be transparent about the headwinds that our agency has faced. Our 120-day case resolution target for cases not requiring a hearing is one of the targets that we failed to meet in FY25. With our growing caseload and a period of staffing shortages, our average processing time increased to 147 days. That's 27 days above our goal, and I do not take that lightly. What I can tell you is that we know exactly why it happened. We have taken concrete steps to address it, including staffing investments that I just described, and we remain committed to closing that gap. What I'm particularly proud of, not a single PERB decision has been overturned on appeal. And in fact, courts have affirmatively upheld our decisions 7 times in the past 2 years alone. In the body of work that now includes 14 pending appeals, the record reflects the quality and rigor of our legal reasoning. That is the standard I intend to protect. Chairperson Bonds, the work of this agency touches every district employee who files a complaint, every union seeking certification, every agency navigating collective bargaining. It is work that is often invisible until someone needs us. And when they need us, we are there ready to assist. I am proud of what PERB has accomplished. I'm clear-eyed about our challenges, and I'm committed to this agency's continued growth and excellence in the service to the district. Thank you for the opportunity to report on PERB's performance. I look forward to your questions.
Thank you very much for your testimony, Mr. Sims. And I would like to start with you. You make a real declaration here where you acknowledge that your 120-day case resolution target is not being met. So I have to ask you, of the cases that you have today, you opened 44 in the first quarter of FY26. Have any of those been resolved?
So yes, we have resolved some of those cases. The case flow at PERB is structured so that the earlier we can resolve the case, we will. And I believe it's vitally important to expeditiously get answers to both parties, labor and management. So some cases are resolved through administrative dismissals or a judgment on the pleadings or briefings. Cases that take longer, you typically require mediation and hearing services.
So today in your shop, how many cases do you have that your staff is working on? Of the different cases, that you give us a number for? Or I could ask you, in FY23, you said 35 cases were open. Have all of those been resolved?
FY23 cases, I will have to look and provide that information to you.
Okay.
I'm sure that most of them have been resolved. There may be a case or two that has gone through a hearing process that like appeals that would take longer. Additionally, what I can say is that of our current caseload is, we have about 59 cases open. I can also provide like the
So today,
specific number,
today you have 59 cases that are
like
open.
open and continue, yes.
All right. And so of those cases, how many did you receive in 23? How many did you receive in 24? What I'm trying to understand, I mean, you present a mighty caseload. And we're talking about your, well, really, it's been, what, 6 attorneys, but now you have a 7th attorney, right?
We have 4 attorneys, including myself, and the staff of 7. So we have our chief of staff, we have a program analyst, and then we have an administrative support.
Okay, I'm trying to help you build the case for whether or not you need 2 attorneys or 3 attorneys. Whatever you need, we have to work on getting that for you. So I'm trying to understand the time frame that it takes to work through many of your cases so that we can get you the resources that we need.
So again,
Without asking you about your enhancement document, okay? I
so
don't operate that way. I operate on trying to understand what your workload is so that we can get you the resources that you need.
okay, so resolving cases is extremely important to us. PERB has 2 internal goals. For cases that do not require a hearing, our goal is to resolve that in 120 days. For cases that do require a hearing, our goal is to address that case and resolve it within 300 days, so less than a year. We are on target.
Is that the normal for the kind of work that you do within a government structure? 300 days seems some time. I think Ms. Williams from one of the unions said she has a issue that's finally resolved after 7 years.
So typically at PERB, we resolve cases within a significantly shorter time frame than that. Now, a case once PERB makes a decision, that case could be then appealed to the Superior Court.
Right.
And that case can then be appealed to the Court of Appeals. And so the overall
So now we're at 7 years. Yes,
of a
I got
case
it.
can take significantly longer than the actual time that is at PERB.
Okay.
And so, on the staffing point, we haven't been fully staffed since FY23. And so we've made significant progress in getting to the point we are now. I'm excited about our results. I do think that we will meet all of our internal goals once we have our 8th attorney on by the end of this quarter.
All right. And so for your 2 additional attorneys, do you have space for them in the office?
Yes.
Okay. Thank you for that. Do you have an opinion as to whether or not the board needs to be expanded? Would that be helpful?
Our board is composed of experts with significant labor relations experience. They work very well together and build cases on and decide cases on consensus in most cases. I think they function extremely well, and the balance in the law, the CMPA design, management interests on one hand, labor interests on another hand, but the majority of the board is focused is taken from the public to ensure that the public's interest is at the center of our work. I think it's a very good balance, and any decision related to that will be for the council to decide, but I think it's a very good balance.
All right.
That is.
So sounds like if we added an additional labor representative, an additional management representative, and an additional public representative, we would have a board that works for today. And I mention that because of our approximately 37,000 employees, 27,000 are unionized. And I would imagine that we're not given the kind of attention that the labor community feels they deserve because they are the lion's share of the employees. So I'll be working on that also. You mentioned that you bought your website calendar management in-house and that this small change improved accuracy and timelines and how you communicate with the public. Can you give us an example of the value of that?
Yes, so it was PERB needs to making sure that the public knows when we're making decisions, knows when we're when we're having hearings, because our hearings are open to the public. And so we noticed that there was sometimes delays if we had to change a schedule for like a training. There might be a delay in its publication on the website because we had to go through our external partners at Octo. And so we wanted to have more control of that. So we were able to have our staff members trained on the, website platform to ensure that, the information that we're communicating is clear and accurate.
Okay. And then you mentioned that one of your paragraphs said that you've been innovating where you can, and you use as an example, you said you challenged your colleagues at the Office of Labor Relations that were facing. They weren't receiving timely notices when new cases were filed with their client agencies. Can you give us an example of that? I'm trying to help the public to understand our internal whatever that we do, the processes that we must follow in order to make government run. And your two agencies are part of that process, helping people to understand what it takes when they get a service delivery.
So PERB is a neutral arbiter, and our neutrality is very important to us. However, we're also a district agency, and so ensuring that services are provided efficiently and timely and at cost savings is a part of our mission as well. OLRCB identified the challenge that we're having in receiving notices in a timely fashion. And we implemented a process to ensure that for agencies that they represent, they receive that notice in advance. It was a change that, we worked together, we worked internally on how to structure it. But now there's time savings, there's timely notice, and it makes the process more efficient. So,
Hey, you shared with us that if the case, I think you said, if it's in litigation, it's 300 days. Excuse me, please. Sorry about. So what is the time frame in which you now notify the labor organizing office?
so we notify OLRCB upon filing. So
Upon filing, okay.
Yeah.
Thank you. Congratulations. You are telling us that not a single PERB decision has been overturned.
in the last 2 years,
Last 2 years. Congratulations. That's an accomplishment. So with two additional attorneys, you have work for them, right?
we have plenty of work for them to do. Yes.
All right, okay. All right. I think there were a few questions that were generated by the public witnesses and primarily seems that the timely or the lack of timeliness in the resolution of disputes, is that a staff issue, or is it your process is old and antiquated, or what causes that?
I think it's important that parties understand that PERB is acting in an expedient manner to ensure that their case is processed, but it also ensures fairness and accuracy. And so in providing fairness to parties, that includes all the steps of due process. When we have a hearing, that hearing is before a neutral arbiter. The parties present their evidence, and the parties have a post-hearing briefing and an opportunity to file exceptions with the board directly. That takes time. And that's outside of delays or extensions that either party may request. And so in some ways, it takes time to get to the right decision. And I think our record on appeal shows that. But with that being said, PERB's goal is to ensure that internally cases that do not require a hearing are resolved within 120 days, and cases that do require a hearing are resolved within 300 days. We have met the goal for cases that do require a hearing.
All right, does PERB have any authority to suggest or impose discipline on agencies when they are the violator?
Statutorily, yes. We do have that authority. We have not exercised that authority.
All right. Would
And
you please send me a list of what that authority is and what your, I guess your list of remedies? As you say, you haven't imposed them, but you can.
So in I guess there is a caveat in language. Our authority is not to impose, but to recommend.
Yes.
So it's, you know.
Would you please make sure that we get that within the next 10 days,
Will do.
please? All right. And we'll send you a follow-up letter of request for that. Thank you very much. The case with the FOP, what's going on there? What's your side of the story? Because the side that we have heard from the 1,000 employees is putting them in harm's way on the job and for over a year.
A little bit about my background. I represented correctional educators prior to my position with PERB. And so I know what it's like to be behind the wall. I know the importance of having union representation in the correctional setting and the benefits that it brings. And that background was a part, well, you know what? That background is something I carry with me. But in FY25, the board took the step to revoke a union certification as a consequence of the union's failure to maintain its fiscal integrity as required by DC law. This was not a punitive action. It was PERB fulfilling its statutory obligation to protect the rights of union members and ensure the organization representing district employees operates with transparency and accountability. PERB does not just process paperwork. We are a safeguard for the labor relations system itself.
And I appreciate hearing that. My question then would be, in safeguarding the integrity of the process, I would like to know what is your time frame for taking that action. As again, for over a year, these individuals have been without representation, and your office took the steps to conduct an election, to count the ballots, and then decided, maybe you need to, because of a complaint, maybe we need to redo that again. So I'm trying to understand, in your quasi judicial, standing, what is your understanding as to the next steps that should happen, and when do they happen?
So the board revoked the certification. The the employees at the Department of Correction have not been without representation for an entire year. The Superior Court implemented a stay on the board's order until they reached the final decision. That stay has been lifted because the Superior Court found that PERB's decision was supported by substantial evidence.
This is one of those cases that you won.
Yes.
Okay, that we spoke of earlier.
Yes.
All right, so now what are we going to do? You won it, so how do we make this group of employees hold again?
So the board ordered an election. The election took place. The results were FOP was successful, but the election was challenged. There were objections to the conduct at the election. In processing those objections, a hearing examiner found that the election could have been unduly influenced by the conduct at the election. So the board has ordered a rerun of the election to be done by mail ballot.
When does that happen?
I have secured a vendor for we've put out the proposal to several vendors. We selected a vendor. We're meeting with the vendor this week, and we will be reaching out to the parties to schedule the election. And it's important that we get this done.
So we will, the 1,000 members will vote again, have the opportunity to vote again. And they'll vote by mail ballot. They did not use mail ballot the first time, I'm assuming.
Correct. The first election was an in-person election.
I see. All right, so will this be done in the next 30 days, 60 days, 90 days?
I want to have this election conducted as expedient as possible.
So you have not set a date?
We have to work with the parties to set the date for the election.
So when do the parties come in? And when you say the parties, that means the FOP and the complainer gets a seat at the table?
So it's an election, it was petitioned for by the AFGE union. The FOP was treated as an incumbent union.
So those
because
two
of the state
unions will meet with you?
and the employer and the Department of Corrections.
Okay, so it'll be 4 of you at the table.
Yes.
And so what happens if the vote is lopsided, 2-2?
So PERB is the body that sets the parameters for the election.
All right. And that will happen. Would you send me a copy of all of the notices that you send to the parties as it relates to your meeting to make a final decision of when the election will take place and then information that indicates that the election is moving forward?
Yes.
All right. Okay, thank you very much for that. Any? Oh. All right. Okay. Yeah. Just so I understand, this issue where you decertified the FOP initially before you conducted the election, just trying to understand what are the parameters by which you do a decertification? I somewhere we read it indicated that an employee would have to make that appeal to you. Is that what happened?
No.
No. Okay, so
It's very-
you're independent enough that you can just arbitrarily make that decision, right?
Never arbitrarily.
Okay,
And this issue is still pending litigation, but there is the language that we use is very important. PERB did not decertify the
All right.
FOP. PERB revoked the certification of the FOP for their failure to comply with the standards of conduct to maintain the fiscal integrity of a labor organization.
all right. Thank you very much. That is on the record now. Thank you very much for that. We just have a few points we wanted to, just for the public's edification, the board consists of 5 members, which are appointed by the mayor with the advice and consent of the DC Council. The public should know that that is customary throughout the government. I believe we have over 150 boards and commissions where this is the process that the individuals make application or are recruited. They go through presenting their resumes and any other information, including I would say endorsements from their employer or endorsements from neighbors or community. And then the mayor's office of talent makes some preliminary decisions so that they qualify for appointment to these boards and commissions. And then the council has an opportunity to hold a hearing similar to what we are experiencing today, where the applicants, the nominees, as we call them, come before the council. We try to examine them, make sure that not just that their finances are in order and they do not owe the government any remittance, but also to make sure that they understand what they're being nominated for, because 150 boards and commissions is quite a lot. But that's been the process for at least since the late 70s, 1970s in the District of Columbia. So if someone thinks that somehow, individuals who might want to be on these boards are not given a fair opportunity, I just want them to understand the process. It's just a routine process. The board is tasked with multiple responsibilities, such as adjudicating unfair labor practices and complaints, considering appeals of grievance arbitration awards, and facilitating the resolution of impasses in contract negotiations. So that's the board. Now I have just a few questions. As I mentioned earlier, the board, PERB has seen a significant increase in its caseload. That's your testimony over the past few years. Could you give us some indication of what's driving this growth? Is there a pattern of certain types of grievances or complaints that you receive that might help us to understand what's going on in our government?
So I don't know if there's a specific pattern of cases that we receive. We've received more unfair labor practice complaints. I think in general, there's more knowledge about labor relations. It's in the news a lot, and I think that people are more willing to exercise those rights related to their collective bargaining and under their contracts. So I think just more knowledge, more activity generates more complaints.
Okay. You've already acknowledged that it takes a while to go through the quasi judicial process of resolving these, so I won't ask you about that again. And we talked a little bit about the FOP. And can you talk a little bit about the board meetings that are open to the public? I know there's certain portions you close using DC Code 2-575. Can you help us understand what are those parts of a meeting that might be closed to the public?
Yes, we close the meetings for deliberations of the board decisions. The structure of our meeting runs according to Robert's rules, DC in the DC Code. So we call it to order. We have a quorum call. We open the floor to the public, and then we provide a summary of the cases that we're considering for our docket. Once we tell the public what we're considering, we typically close the meeting for deliberations on those issues, and then we reopen the meeting to announce those decisions.
All right. Well, thank you very much, Mr. Sims, for your testimony today. We'll see you perhaps in April, and when you'll be able to give me some estimates of dollars that are needed.
Thank you very much.
Thank you very, very much. Mr. Maxwell, welcome to Day. Thank you for your testimony. Of course, you heard some of the concerns that our public witnesses expressed. They do not like the fact that you represent management. So can you help us understand why you represent management and what is your role in the, I guess, putting together these contracts that our unionized employees operate under?
Sure. Good morning,
Good morning.
Chairperson Bonds. And I know you like to do this for the benefit of the public, so I'll stay with theme. Let's say you have officers at the Department of Corrections, and those officers have a right under the DC Code to unionize. This is a union town, so we have a statute which allows them to unionize. Once they unionize and they want to negotiate a collective bargaining agreement, or they want to have grievances or any type of litigation, they would have to do that against the employer, which in this particular situation would be the Department of Corrections. And so OLRCB represents the Department of Corrections in that case. And similarly, we represent all agencies under the mayor's personnel authority for any similar type of labor issues.
All right. And I have just a few questions for you. You heard the testimony from the teachers the teachers union.
I did.
In particular, they're very confused as to why the teachers, I think 150, received this $2 million. And maybe it's the manner in which it was transmitted, maybe because the teachers union leadership has changed and there is not proper documentation that follows or precedes the money. But help us to understand, because I must tell you, if I were a teacher and I received some of that $2 million, I'd be happy. But I would like to know why I'm so happy.
Understood. You mentioned confusion.
Yes.
The WT was confused. I would agree. However, this case is still part of active litigation, and for those reasons, I would decline to publicly comment on them, but certainly offline, I can provide you with as much information as you need.
All right. Okay. I guess then I have to ask to close the case down. Does your office have all of the necessary documentation that at some point would be available to the teachers union and to the teachers that receive this remittance that would help them understand why they received it? Now, I do know that this has been the teachers union has been concerned with this issue for over 10 years. And I don't understand what that really means, how they can be concerned with it for over 10 years. So if there are teachers that were eligible over the 10 years, would this $2 million cover the 10 years, or does it just cover FY 25?
Sure. Without getting into the weeds of the
Yes.
particulars, I can tell you this. The case involved, let's say, 10 to 12 years worth of cases, but those cases weren't all filed as one case. Those cases were filed as separate cases, and they proceeded along in a separate manner. And so that's why it's still part of active litigation, because part of the issue here is how much time is this decision supposed to cover?
All right. That's part of the,
That's the main issue. One of the
yeah,
main issues.
that would be my issue too.
Sure.
So, and I'm not over there at the court, so I would be wondering yeah.
Yes.
Thank you for that.
Absolutely.
That seems germane to the whole piece. Well, ladies and gentlemen, the Office of Labor Relations and Collective Bargaining is the principal advocate for the district's labor management program and the primary litigators for the district's labor disputes. It is responsible for negotiating agreements between the district government and labor organizations. It is also responsible for managing agreements that cover thousands of unionized employees. So just want to make it clear that this is their purview. They are not the PERB that you heard about earlier, but they're primarily concerned with the contracts. And the contracts are negotiated contracts last about 3 years, but they're negotiated probably every 2 years or 4 years when we miss a year. What's the reason for missing a year? Are you on purpose trying to delay the negotiations process because the district government is sometimes unclear as to the amount of resources, revenue that it has
Sure.
on hand?
No one ever tries to unduly delay any negotiation that we have. Key word here being negotiation. Negotiation involves both parties working together. And so sometimes delays are just inherent. People have scheduling conflicts. We can't get an arbitrator. People need more time to prepare. Delays are inherent. You know, I tell people all the time, if you're in a CBA and you don't like the delays, you can negotiate for better, but you have to be clear that in any time, in any negotiation, there's give and take. So if you want us to move, you're gonna have to move on something. And that's just not me talking, that's the science of negotiation. That's the principle of labor law. Anything can be negotiated as long as it's not in a legal subject of bargaining. And then, of course, we have management rights, which is carved out by the statute. Everything else is fair game. So if you don't necessarily like the time limits, you can negotiate for something else. It just means that you're probably gonna have to give on something in return.
Mr. Maxwell, I hear you. And I think that's really one of the issues that we've heard today, that I'm not sure that our labor community is following along and understands that you start from the point of the current agreement. And from that point, both sides negotiate to give a little so that the other side can have a little more of what they want. I think that's what I'm hearing. Am I correct?
That is exactly correct.
All right. So in other words, if a labor union wants to cut down on delays, that's what we heard. They think that my contract, as an example, I'm in my second quarter of my third year. Should I have requested negotiations to start in the next quarter, or what should I do?
Sure. The rules say that your request to bargain a collective bargaining agreement should come, I believe it's 60 to 120 days before the start of the fiscal year in which it will expire. So
Okay.
so I can give you an example. So a CBA that's going to expire at the end of this fiscal year, which would be September 30th of this fiscal year. The request to bargain should have come to us back in like June, because the fiscal year starts in October 1, and when you count back 90 to 120 days, you wind up in that summertime.
Okay, so that would be at least by the third quarter.
Yes.
Yes, okay, all right. I was wondering if
Yes.
I had calculated.
You got
right.
it. Yes,
Okay,
ma'am.
all right, okay. All right, so that's the process, but do you also have a rule where that there's a pecking order? We have about 14, 15 different contracts that you manage?
It's more than that, but yes, we
Oh,
quite a few.
how many do we have per
I
within
believe-
our government?
I put it in I think it was an answer on one of the
Yes,
questions.
let me find my. Don't think you put it here. $25.
I'm sorry,
I see a number negotiates 25 separate compensation agreements. Is
Right.
that pretty
that sounds correct. But those are,
accurate?
let me just say, those are compensation agreements. We also have working conditions agreements that are separate in some cases. from some agreement. We have three different types of agreements. We have compensation agreements which cover just compensation. We have working conditions agreements which cover working conditions. And then we have some that are actually combined, where it combines working conditions and compensation in one agreement.
So help me understand, what is a working condition agreement?
So a working agreement covers everything that's not compensation. What's the procedure for when you want to call off to work or take a sick day? What's the how do we decide how people get the premier assignments? Is that done by seniority? How do you come up with a seniority list? What's the procedure for changing schedules and changing shifts? That's all. That's part of what we would call working conditions.
And approximately how many fall into that, in addition to the 25 compensation agreements?
I can count those for you because I believe under tab.
Okay, because I think I heard about some of those needs from the public witnesses today. I think AFGE mentioned their concerns, bullying, behavior, treatment that employees are allegedly receiving.
I'm counting roughly 25 working conditions agreements.
Additional, okay. All right. So what's the size of your office to manage all of this?
20 total employees, 11 of which are attorney. I believe that's right. 11 of which are attorneys. And then we have a great support staff and then the director.
All right, and so the compensation agreements, the working condition agreements, 25 plus 25, thereabouts, that's 50.
Mm-hmm.
They all go through your legal staff, am I correct?
That is correct.
And for any one compensation agreement, you have, what, 2 attorneys working on it, or?
That's a good question. You mean for for compensation agreement? It all depends on the compensation agreement. It all depends on the agreement. All of the agreements that we have are they're never one size fits all. Some are relatively simple. Believe it or not, most of our contracts with our unions are not a big deal, especially when it comes to working conditions, because when the time comes for them to be reopened for negotiation, there's not a lot that the parties really want to change. And so maybe for that, there's always going to be at least 2 attorneys on one. However, like we start talking about our comp units 1 and 2 negotiation, which covers a large swath of our employees. When we do that, usually it's a team of people. It might be as many as 9 or 10 attorneys working on that agreement at any given time.
How many union members are in comps 1 and 2?
I believe it's around 10,000.
10,000. And are they with AFGE or ASME or?
They're spread out over a lot of unions. AFGE, we have AFSCME, a bunch of AFSCME locals, NAGE, the National Association of Government Employees, Teamsters. Those are major
We
ones.
combine them.
The
What's
reason
the value?
the value is that we're able to negotiate salaries in one cohesive effort without having to do a whole bunch of small ones. And so that process is initiated through PERB. We take compensation units and we're able to get their approval to negotiate them all at the same time. It saves time and everybody agrees it's the better thing to do, and that's why we do it.
All right, but it does not include FOP.
I want to be clear, it does not include FOP that's at Metropolitan Police Department. That's a separate deal. But our Department of Corrections, which I think you were trying to get to.
Yes.
The Department of Corrections are included in comp units 1 and 2.
All right. So do you have the authority to weigh in on the situation as it's been described by Mr. Alexander on behalf of his FOP?
Unfortunately, I do not. We take no position or opinion on that case, as we are not parties and has absolutely nothing to do with OLRCB.
All right. I just want it on the record, one way or the other.
Yes,
Thank you very much for that. Mr. Maxwell, Mr. Gilliam is ready, willing to meet with you. Are we going to set up coffee or breakfast soon?
My assistant's already typing up the email to send him to schedule him.
All right.
I will not do another coffee until I do one with Mr. Gilliam.
All right. And would it also be appropriate for you to do an additional one, but this one with Miss Williams?
Absolutely.
She's wanting, thank you very, very much. I think that helps us to move the ball. You know, we're all one. And I think in recent times it's been made so clear to us as we have embraced the fact that we are a federal jurisdiction. We are not a state. No matter how much we aspire to it, no matter how much fiscal autonomy that we have been able to achieve. And so, in other words, we're one big family. And so I appreciate you being willing to do that. And I hope that's one thing that they can take away from today. I should have asked Mr. Sims about his opportunity to meet with Ms. Wilcox, but we'll arrange that after we meet. I think trying to clear up these matters as quickly as possible is the direction we want to move in. So I'm very anxious to be a party to move these matters as quickly as possible. Currently, do we have, how many unions do we, or compensation agreements are outstanding for this year?
Let's see. I can just,
Okay.
I can give them to you real quick. There's the compensation units 1 and 2 agreement. There is the DC Nurses Association. There is Doctors Council. Those are our doctors at DBH. DCPS, Council of School Officers. Those are our principals and vice principals at DC Public Schools. AFSCME 2921, which is our DC Public Schools paraprofessionals. I believe that's it.
And that accounts for how many approximate
I believe that was
employees that we have?
so 1, 2, 3, 4. Oh, I'm sorry. There is there might be a couple more. There's the fire department.
Ah, okay. That's pretty big.
That's a big one. There are judges at the Office of Administrative Hearings. Who's that? Okay. Teamster, there's our bus drivers at AFSCME 1959. Those are our our full-time bus driver. I'm sorry, those are our part-time bus drivers. Is that right? Those are part-time bus drivers. And then we have Teamsters 639, which are our full-time bus drivers.
So 639 are full-time. Okay.
That's
All
correct.
right. So that's what,
I
about
think I gave,
3,000 employees?
which one is that?
All of those that you mentioned.
Well, comp units 1 and 2 is 10,000 by itself.
Ah, okay. So it's 10,000 plus. So, so how are you staffed for that? You okay?
We're fully staffed. We're ready to go. on whatever negotiation.
2 additional staff, would that help?
It would always help, yes.
All right. You don't have to go further. I just need to know. See, I want to know because when I'm with my colleagues and we're talking dollars and cents, if we need something in this committee, I should be able to say that we need it and, and fight for it. So I just want to know. Now, I don't want any waste. Don't tell me you need them to just be around. I mean, it would help, I would assume, in your negotiations.
Yeah, absolutely. And we, like I said, we have contracts that are, as soon as we get authority and we're ready to move, they'll have to be done.
Okay, when you say as soon as you get authority, what does that mean?
By law, we're not, OLRCB, we're not allowed to move forward and negotiate any contract unless we've had clearance from the mayor. Obviously, she's the executive, and the city administrator.
Both of them in my committee.
Yes, ma'am.
Okay. So I'm just trying to understand the push, the pull as it relates to getting through these agreements. Do we slow down in being responsive to a union because we're unclear of the revenue that we may have? Or do you just take them like, they're on the board, their time is coming up, let's move the agenda? Or is there some fiduciary considerations that you must, deal with as well?
Sure. So I want to be sure I'm clear. The fiduciary duty doesn't rest with OLRCB. I liken what we do to air traffic controllers. We have contracts that are lined up, ready for takeoff, and we're in the control tower. We can't move those planes until somebody says it's time. It's time. We have budget. It's the right time. And those decisions aren't made at OLRCB.
So then I should speak with the city administrator about his timing,
Yes, ma'am.
since he's the time clock.
Yeah. He's the one who gives us the authority.
I will definitely have that opportunity soon.
Yes, ma'am.
So thank you. Just trying to help our labor community to also understand how our agencies that handle their business, is also positioned to move forward or not move forward. So
Yes.
just wanted to, okay. So what communications do you have with unions during, I'll say, I call it the wait period between the submission of their intent to bargain and while they are hovering around the airport and not yet been told to take off?
There's a few different, there's always some level of constant communication with us. I can tell you that unions oftentimes will reach out and they just want to know, they just want information. Where are we with this? What time? And then, we also can move forward in some respects, right? We start the process of ground rules. And once we do that, if the other side wants to give us their opening proposals, we certainly can take those. We may not be able to get back to them until we get the clearance from the tower, but we certainly can take those. And that gives us a good idea of what's pressing for the union. So there's constant communication going on periodically about the contract while we're waiting.
Right. Is your office involved in the agreements with, let's say, DC Water, which is one of our independent agencies?
No, ma'am, we are not.
What about Events DC?
No, ma'am, we are not.
All right. But public schools,
Yes, ma'am.
which is independent.
Yes.
All right. Library?
Yes, we do have employees at the library.
Right. Do you have internal controls or review mechanisms in place to monitor collective bargaining agreements that are approaching expiration, or is it up to the union to reach out?
The code puts the onus on the union to submit that request in a timely fashion. Of course, we're always keenly aware of when one is coming due, and so we keep an eye on the calendar to be sure that we get the request, on time or in time.
And I believe the unions also are required to submit some sense of how they want to proceed to you before you take up the issue of negotiations. Am I correct?
Well, they'll send us their request, and then what we do is we'll start talking about ground rules.
Yes.
How many people do you want on your negotiating team? What's the process for having visitors come in? The confidentiality piece, those things are worked out. Sometimes that can take a little time too.
All right. What's the average time that it takes to work out ground rules?
Usually it's not long. It's not normally it's not long.
So
When I say not long, if we're pressing it,
90 days?
Oh, for sure.
Okay.
For sure.
30 days?
That a little bit more challenging, but possible.
All
You're
right.
probably looking, the sweet spot is usually between 45 and 60 days.
Okay, I think that's important because we've heard today about the length of time that it takes to get resolution to grievances. And I'm just hoping that the public understands that this is an internal process that is constantly churning while we, the citizens, get the service delivery.
I have to speak a little bit, if you would allow me, about this issue of delays, especially when it comes to grievance arbitrations. In the labor industry, arbitrators are at a premium because there's not as many of them. Most of our arbitrators are older, they're retiring, they're dying, they're getting out of they're just getting out of the profession, doing other things. So delays are not always the fault of OLRCB, nor are they the fault of the other party. To be honest, a lot of times the issue comes when you go to strike for an arbitrator and you pick one, and then that arbitrator's availability is not until 8-9 months out. It's not anybody's fault. That's just the way that it is. And so, when you start to look at something goes wrong in January and a grievance comes in, and it goes through the internal grievance process, and we now know it's going to arbitration. Well, right there, you're probably looking at maybe 60 days, 30 to 60 days, where you're like, okay, we weren't able to resolve it. Let's go to arbitration. So then you go to select an arbitrator. That might, you have to send to AAA, the American Arbitration Association, for a list of arbitrators, and then you schedule to strike them. And then you find out we've picked this arbitrator. Let's reach out and let's schedule the actual arbitration hearing. We're going to need 3 days of arbitration hearing. Well, if you're going to need 3 days, you got to find an arbitrator who's got 3 days on his or her calendar to hear that case. And I can tell you right now, on average, if that case comes in February or March to an arbitrator and he has to schedule, you're probably not going to get on that arbitrator's calendar until the fall. And if you're not getting on until the fall, remember, you need 3 days. Usually you want those 3 days to be consecutive, but sometimes the arbitrator can do 1 day now, and the second day 2 weeks from now, and the third day a month from now. Now you're in the January, February, add time for briefs. Everybody wants to file a brief. You file a brief, then you have to wait for the arbitrator to write the decision. So I just laid out a very simple case of how something that happens today, happens in January, you may not get that decision for a year. Now, we haven't even talked about the appeals procedure. If we want to appeal that decision to PERB and then the Superior Court. So they can take a while, but that's what we have, A. And also B, I'll go back to what I said earlier. If you want something different, we can negotiate something different.
Thank you for that. I have to ask, does your office have the capacity to train others to become arbitrators?
No, we do not.
You do not?
No.
But I think you would agree that that is a workforce category that we really need to be looking at.
I would agree.
Okay. Thank you for that.
Chairman Barnes, can I say something else? Just want to, something else to my comment. It could take a year to get a resolution to your issue, which is why arbitration is not the best tool in your box to use for certain issues. Certain issues, you should just put in a phone call. I tell you can call me, you can call the director. Filing a grievance is great, and certainly you need to preserve your legal rights, but sometimes there's better ways to fix the problem than to file a grievance.
All right, so what are better ways than arbitration?
Pick up the phone, call somebody. When we were going through COVID, and I understand it was COVID, we kind of pivoted a little bit. OLRCB became more of an agency. We called ourselves more of a bridge agency. We had relationships, and we were hearing from our labor leaders about, we don't have enough PPE, we don't have enough hand sanitizer. They would tell us. So, and it was like, great. When we knew, we would transmit that to the city administrator and let him know, I know you're hearing this from your agency head, but I'm also hearing from the union that they don't have enough PPE. That team approach was what got us through COVID. I mean, we saved lives because we were able to pivot and serve as this bridge agency. And that still holds true. I get calls all the time from, there's a problem in the terminal garage or whatever. There's a problem. And it's like, okay, you have a problem. What do you need? Well, let me get on the phone with the director.
Okay.
Let me get on the phone with the CA and see if
All
I can
right.
help. No one's trying to unduly delay. No one's trying to obfuscate. We just want to be helpful, especially in situations where safety is at issue.
So I assume then you are available to look at this issue, perhaps with rodents in DC Housing Authority building.
I am open to serve in any way that I'm
Okay,
asked to serve.
Mr. Gilliam is going to talk with you when you all have breakfast about
Look
that.
forward to it.
Okay, so we make sure we get that done. Thank you very much for that. Yesterday, UDC was before the Committee of the Whole, and to follow up on prior discussions, can you provide an update on the university's collective bargaining negotiations and confirm the anticipated completion date? They're saying July of this year.
I can't confirm that because we don't handle their contract.
You do
negotiations.
not. Okay. What lessons has your agency learned from prior impasse situations, and how has this informed improvements to your negotiations process?
We've learned that going to impasse arbitration is about as fruitful as rolling dice. You don't know what you're going to get. You don't know how an arbitrator is going to decide. Sometimes you don't even get a decision that's explains it well. I can also tell you that it has been extraordinarily difficult negotiating now that we've changed the whole issue of what's the competitive area. Geographically, it used to be the DC metropolitan area, and sometimes we would look up and down the East Coast corridor. But ever since the Fair Compare Act, we now have opened up compensation to be compared with people anywhere. And so folks here want to make the money that people in Honolulu are making, or San Francisco are making, or Dallas, Texas are making. That makes negotiations more difficult from our standpoint. So, I know we've talked about in my office about what we could do to maybe get that legislation turned back, look at other alternatives. But we've learned that when it comes to impasse arbitration, it really, there's no telling what you're going to get.
So you're working on legislation. Do you think you'll have it ready for presentation to the council this year?
I don't know if I want to say we're working on legislation. We certainly have been discussing the possibilities of it with our partners at OPLA and OCA.
All right. I have a question about management rights. You heard a little bit about that today.
Yes, ma'am.
What does management rights mean for you as our chief negotiator with our compensation and working agreements?
Sure. As I said earlier, anything is negotiable unless it's an illegal subject of bargaining. And so we have carved out, though, management rights. And again, let me explain by example. At the fire department, when they change shifts all the time, police department too, it's a shift changing business. There's always people switching shifts, changing shifts, getting reassigned, rescheduled. If we didn't carve out management rights, we would never be able to do that, because whenever we would change any one person's schedule, that would trigger a requirement to bargain with the union. So to get around this, the code has carved out management rights. And those management rights include things like tours of duty, how we handle security, those types of issues, how we manage and organize the agency. Those things are management rights. We do not have to negotiate those with the union. However, when we make changes to any of those management rights, it triggers the ability for the union to request from us impact and effects bargaining. And what impact and effects bargaining is, it allows us to negotiate with the union over the processes and procedures by which we implement that management right change. So if we're going from a 5-day shift to a 4-day shift at MPD, well, that's what we're doing. That's a management right. MPD can do that, but they have to negotiate over the impact and effects of that. How are you making the changes? Is it by seniority? How are you determining seniority? Is this grievable? Those things are allowed to be discussed with the union. And again, it's bargaining, but you don't bargain to impasse because it's a management right. You try your best to reach an agreement with the union, but if you can't, you implement as originally planned.
And so you're saying that tour of duty and security of the employees, of security of where they are.
Like the security of the building?
The building,
Right.
okay, all right. Yeah, are there any other?
There are others. I can get you the list.
Would you please?
Yes, ma'am. Absolutely.
Okay. All right, want to make sure that we have that and understand it within 10 days, please.
Sure.
There's a question about public school principals and vice principals. That is there management prohibiting that group of employees from unionizing, to your knowledge?
Well, the principals and vice principals,
You mentioned.
they're in a union. Yeah,
you mentioned that.
they're in a union. But while we're on the topic, just so we're clear for the record, we do not handle schools outside of DCPS. So charter schools, which I know
Correct.
we seem to get questions all the time about charter schools. We don't do charter schools.
All right, so do you do the adult charter schools?
No, ma'am.
Okay, so only DC public schools.
That's correct.
You received 44 adversement requests on a host of matters such as disciplinary actions, employee performance, reductions in force, and desk audits. What's the purpose of these adverse requests that are the intended outcomes? And what are the intended outcomes?
I think you're talking about the advisements that we give
Yeah.
to, we on a regular basis consult with our agencies. And we give, we have cases that come in, right, which is litigation. We have the negotiations, which we've talked about. Then there's this other bucket we have, one for training. We train the district employees on district management on management and in a labor environment, labor and union environment. But then we also advise agencies on issues that they're seeing or that they're having before they become litigation. So they'll call and say, hey, we want to do X. And it's like, okay, you know you're going to have to negotiate with the union. And it's like, okay, so now we have something you want to do. We devise a plan. We we do a letter to the union. We let them know that we're making this change. If you want to have I&E, let us, like we do all of that is what we call an advisement. And so I think that's what you're looking at in our KPIs.
I think,
Yeah.
yes.
Yes.
Yes, okay. So are we at a point in our government where all of our employees should be assembled and you should share all of these recommendations across the board? Is it time for us to do something like that? Would that be of value to help everyone understand management rights, understand how impasse negotiations is, a very slow process? I mean, would that help us to grow as a organization, government?
So this is something that we've been discussing with DCHR and maybe as a part of their training component that they do. We already do extensive training for everybody in DC government who touches labor. So we have our labor liaison forums, which we hold periodically throughout the year. And we workshop different things that are going on that we're seeing. And so that we can all be aware, because I tell people all the time, just because you see something going on at agency A, you have to understand that agency A is covered by a union, and that union's got locals all over the city. And so please coordinate with us, because there might be something we're trying to do at another agency, and what you're about to do probably may affect that. And that's really more so a thing of strategy. And so just being sure that we keep everybody abreast of what we're seeing. We already do that periodically. And then there, for a time, I know that PERB was doing, I think it was it was like monthly, every Tuesday, they would do trainings. The great thing about those trainings were that they were for both management and labor, because PERB's the neutral. They would just provide general labor training, which was very effective and very useful. At least while I was at PERB, it was great. We used to get really good attendance, and it was a really good environment because labor and management were in there together. So you got to interact with people that you probably wouldn't normally interact with and hear about their issues that you wouldn't normally hear.
So it sounds like if there were such a gathering in June, September, you would be very much a part of it, along with all of our agencies and all of our personnel, like employee jamboree or something. As you said, getting to know each other can be a solution. You mentioned that. You said pick up the phone, reach out, talk. So
Absolutely.
we could, yes, I, 50 years is time.
Agreed.
That's my thinking. Thank you very much. You mentioned something about visiting sites for training. Tell us what that means.
So we just actually did one last week. I had two of our attorneys or staff attorneys went and did a training at OUC, the Office of Unified Communication. And they went for the evening shift, which I was really happy to see. So they went from 6 to 8. They're able to meet people in the agency, at the agency, and do some training, meet some people, and understand some of the concerns that were going on at OUC. Prior to this, when I was at DCHR and sometime after with Director Hall, we made visits to agencies as well, just like in the middle of the day. So we would coordinate with the director. I think the last one we did was at DPR, where me and Director Hall went. We took about 5 staff members each with us, and we went and we just did hey, we're just here to meet everybody. We want to hear your questions or concerns about labor, about HR, about benefits, about your CBA. And it was a great way to, again, touch people that we don't normally get to touch. And then we would break off into, we would do a session with the unions, and Director Hall would do a session with all the other employees. And so we like to continue doing that. We usually on an annual basis make a visit to the Department of Corrections. So yeah, we love getting out. I tell all of my staff all the time, go out and meet people. You know, this business is about relationship building, and the best way to do that is to meet people at their place of business where they conduct. And also when we do cases, it just makes sense. You know, if we're doing a case involving a Department of Corrections officer and his or her conduct, I think it serves us well if we get to visit that area where this incident occurred. And that, you know, that could be anywhere in the district. So we try to get out and do as many site visits as we can.
Well, I appreciate you putting that on the record. Having been in government, our government for some time, I do recall we did a couple of things similar to that, you know, like making government work better. We bought all the employees could come and yeah. And we did one for the public so that they would understand. Sometimes you have to reach out beyond your usual to really get everyone on board again.
Yeah,
So
agreed.
50 years, that continues to stick in my head as to what we have before us as
Yes.
we try to move into this newness. So thank you very much for your time and attention today,
Sure.
and for joining us, testifying with us today. Thank you all very much.
Does that conclude our
Yes, sir, it does.
Well, if I can, ma'am, I just want to say thank you to you for your leadership on this committee. Since I've been able to do this under your leadership since you came on this committee, and it's been a delight. You and your staff have always been very professional, very courteous, and we appreciate the attention that you give to this topic. We feel like it's probably one of the most important in the district, and you've done it well. So thank you very much.
Oh, my goodness. Thank you very much. I appreciate that. And for the public, this is my last year in our government in this role. And so I appreciate hearing what I consider good news, stuff that we've actually been able to do and hopefully make a difference. So thank you very much.
Thank you.
Next, we will hear from the Director of the Department of Employment Services, but we're going to take a 15-minute break, and then I'll say we'll come back at 12:30, and then we will resume. Matt? 12:30? All right. We're recessed till then. Thank you. Well, thank you all for being here. We will now hear from the Department of Employment Services. We will first swear in the director and her team. So if you raise your right hand and affirm, swear that the information you share with us today is complete and accurate.
It is.
All right, thank you. Thank you very much. We have heard from public witnesses about the Department of Employment Services on February the 11th. So today, we look forward to speaking with the director and her team. The Department of Employment Services is the lead labor and workforce development agency for the district, administering a vast array of programs and services available to both current employees and to job seekers to strengthen our workforce. Workforce development is not just about jobs, it's about dignity, stability, and public safety. And I'm particularly interested today in learning about new and innovative ways to engage our young people through employment and how we are doing all that we can to get adults in the job market. I'd like to see what we're doing with the expansion of internships, apprenticeships, and hands-on training so that our workforce can gain real experience, build soft skills, and unlock doors that might otherwise remain closed. As we look ahead to the redevelopment of RFK campus, we want to ensure that district residents are first in line for the jobs it creates through the generational opportunity. From construction to long-term operations, we should be intentional about preparing and hiring locally, and that is at the campus, but in general across our city. When we look at the numbers that tell us that 75 thereabouts percent of the employees in the district are non-district residents, we cringe, wondering how do we get more of our people in these jobs. So today, that will be our interest. We may not get there, but every time we meet, we strive towards that. So now we will hear from our director, Dr. Morris Hughes. There you go. Thank you very much for being here.
Well, thank you and good afternoon, Councilmember Bonds. I've shared my testimony in advance, but I will be reading, for the sake of time, an abbreviated version of my testimony, but you have the full version. Well, good afternoon. My name is Dr. Unique Morris Hughes, and I am the director of the DC Department of Employment Services. Thank you for the opportunity to testify to DOES's performance during FY25 and our progress in FY26. For the past decade, under the leadership of Mayor Bowser, the Department of Employment Services continues to advance equitable workforce development, strengthen economic security, and ensure that every district resident has access to meaningful employment opportunities. DOES serves as the district's lead labor and workforce development agency. Our mission is to connect DC residents to jobs, administer critical social insurance programs, and enforce labor laws that protect workers and employers alike. We administer the unemployment insurance program, paid family leave, and worker compensation programs. We provide comprehensive employment services through our American Job Centers and deliver innovative workforce and apprenticeship programs that prepare district residents, youth, and adults alike for future careers. This work has been guided by our clear vision of hope, helping others persevere equitably, serving as our roadmap for building an inclusive workforce system that connects residents to quality jobs, supports employers, and strengthens committees. I'm honored to have led the agency through these efforts during the last 10 years. Over the past decade, more than 313,000 participants received staff-assisted career services from DOES. supported by nearly 1 million workforce interventions through training, career counseling, paid work experience, and credentialing pathways aligned with in-demand industries. The Department of Employment Services helped residents take meaningful steps towards long-term stability and economic mobility. Through its American Job Centers in FY25, DOES served nearly 32,000 unique participants, delivering over 77,000 career services. Across locally and federally funded adult workforce training programs, DOES consistently achieved over 50% of its participants gaining unsubsidized employment, reinforcing our commitment to family-sustaining wages and opportunities. DOES also administers high-quality training opportunities for in-demand local jobs. This involves targeted skills training in high-growth sectors, intensive support for those facing the greatest hurdles, and direct connection to employers who are hiring now. The DC Infrastructure Academy is part of this strategy, serving as a direct pipeline for the in-demand infrastructure jobs of the district. Since its launch in 2018, DCIA has trained over 5,300 participants with a 69% employment rate. In FY25, DCIA served over 400 participants, of which 368 of them participated in occupational skills training. 82% of these participants successfully completed the training. This accomplishment not only earns them an industry-recognized credential, but it also equips them to enter the profession or trade, paving the way for sustainable economic advancement. DCIA continues to expand its information technology commercial driver's license and energy training program as it prepares for the opening of its new Spincarn location in 2026. DOES also provides vital on-ramps to employment for district residents with barriers to employment, including returning citizens. The Division of State Initiatives Project Empowerment has led the way in creating such opportunities. In FY25, DSI served over 1,500 participants with 1,225 completing comprehensive job training and life skills training. Through a structured approach that includes dedicated case management, career coaching, and subsidized work experience, the program creates clear pathways to permanent employment. As a result, 681 participants have secured short-term or long-term employment during FY25. Over the past year, DOES has driven transformative innovations that are reshaping workforce development in the district. In FY26, we build on this moment by strategically investing federal and local funds to expand high-impact initiatives. Our goal is not just to train individuals for jobs, but to build career ecosystems that support them, our key industries, and create lasting prosperity for residents. A cornerstone of this strategy is our focus on apprenticeships, a proven model for building skilled and dedicated talent. We are proud of our recent partnership with Amtrak, which is creating new pathways into skilled rail occupations. And in May of 2025, we proudly launched the nation's first registered apprenticeship for AI data annotators, placing the district at the forefront of the region's expanding artificial intelligence footprint. Our commitment to innovation is reflected in our work to expand our apprenticeship portfolio. We're focused on growing beyond our current 319 sponsors and increasing our ranks to 6,573 registered apprentices. This includes funding 160 out-of-school youth-focused pre-apprenticeship opportunities in FY26 to ensure our young people have early access to these career-building pathways. The Department of Employment Services recognizes the importance of connecting district youth with numerous early opportunities for positive development by offering an array of access points to career pathways, occupational skills training, building soft skills, and work experience. Last year, DOES opened applications for the upcoming 2026 Marion Barry Summer Youth Employment Program. In FY25, MBSYEP served nearly 13,000 youth between the ages of 14 to 24 at 729 employer sites, with 54% of those participants residing in Ward 7 and 8. Over the past decade, DOES provided more than 126,000 opportunities for young people who gain firsthand work experiences through the program. Additionally, DOES Career Ready Early Scholars Program provides students ages 9 to 13 with opportunities to engage in career exploration. Between 2024 and 2025, CREST provided approximately 900 opportunities to young people expanding career exploration in healthcare, IT, science, technology, engineering, and math, and public safety. In FY25, over 500 district youth completed the program, of which 60% resided in Ward 7 and 8. In FY26, we received nearly 3,000 applications in the first 48 hours of the application launch on January 26. In FY25, the Youth Apprenticeship Program expanded host sites and introduced non-traditional pathways in healthcare and IT, ensuring broader access for district students. The Youth Apprenticeship Program also met its full enrollment goal of 60 participants in FY25, with 88% earning nationally recognized certifications and/or transitioning into full-time registered apprenticeship programs upon completion. Notably, our youth apprenticeship program with Howard University led to the direct entry of 22 graduating seniors from DC high schools into full-time apprenticeship careers as medical coders, telemedicine technicians, and customer service representatives. In FY26, we continued this partnership with Howard University and expanded the program's reach to include student representation across 21 DC public and charter high schools, nearly doubling the reach of last year's cohort. Our work in economic development is also strengthened by the district's commitment to worker protections, with DC consistently earning top national rankings. According to the 2025 Best States to Work Index by Oxfam America, DC ranks the highest nationally due to its strong wage policies and worker protection laws, including paid leave policies, unemployment support systems, and strong anti-discrimination laws reflecting comparatively robust worker-oriented labor standards in the nation. Aside from DOES's charge to create job opportunities for district residents, a core function of DOES is to provide the essential pillars of economic security that allow our workforce and economy to thrive. DOES delivers 3 major benefit programs that often have significant and immediate impact on residents and their families. In FY25, DOES's Office of Unemployment Insurance saw a rise in UI claims from both former federal government employees and private sector workers. In FY25, we adjudicated over 37,000 initial claims, compensating claimants for 423,063 weeks and paying over $172 million in benefits, ensuring timely support for residents during periods of job loss as part of our As part of our fiduciary duty to protect the integrity of the UI Trust Fund, the UI Tax Collection Unit secured $128.5 million in collections, safeguarding the solvency of the UI Trust Fund. Since the office began administering benefits in 2020, the Office of Paid Family Leave has paid over $498 million in benefits. In FY25 alone, DOES adjudicated over 18,000 PFL claims, approving 90% and paying $148.7 million in benefits, continuing to provide critical support for workers and families for bonding, caregiving, and medical needs. Now, the DOES Office of Workers' Compensation conducts informal hearings in private sector workers' compensation matters. The program is fundamental to a stable business environment, providing a fair and efficient system that protects both employees who are injured on the job and the employers who are essential to our city's growth. In FY25, under the leadership of Deputy Director Mohammed Sheikh, the Office of Workers' Compensation approved 100%. They approved 100% of settlements within 14 days, ensuring the safety and the health in the workplace. I'd be remiss, Councilmember Bonds, if I didn't mention that Deputy Director Mohammed Sheikh, after serving 47 years in district government, and DOES is only 48 years old, is retiring on Friday. And he has led this division and supported the division for 47 years. DOES also administers and enforces the district's labor laws, which is the same division, the Office of Wage and Hour. Now, the Office of Wage and Hour manages compliance with First Source Act, investigates wage and hour complaints, provides resources to domestic workers, and evaluates employee safety and health in the workplace. In FY25 and in the first quarter of FY26, Office of Wage and Hour's Office of First Source Compliance delivered measurable results by executing 1,295 agreements, including 625 in construction and 670 in non-construction agreements. The First Source program also created 1,049 jobs, with 165 of those jobs being in construction and 884 in non-construction. First Source compliance efforts resulted in 552 of those jobs being filled by DC residents, which is 52.6% of new hires. The Office of Wage and Hour also enhanced their strategic enforcement of wage theft by hosting its inaugural Wage Theft Awareness Conference. The conference informed district employers and workers about labor protections and strong wage laws that make the District of Columbia the best and safe state to work. Further, OWH increased collection of back wages due to percent in FY25 and has averaged collection of back wages, damages, and penalties over $500,000 in the past 3 fiscal years. DOES is fundamentally committed to protecting the district's most vulnerable workers and providing them with the necessary resources and services. In conclusion, Chairperson Bonds and the members of the committee, DOES remains steadfast in its mission to connect residents to opportunities, strengthen economic security, and build a workforce that reflects the talent and diversity of our beloved city. I'm proud of the progress we've made in FY25 and excited about the future we're shaping together. Thank you, Councilmember Bonds, for your continued partnership and leadership and support. And at this time, myself or either of my 2 senior managers are able to answer questions. Thank you.
All right, thank you very much for your testimony. I wanted to just, if you could refresh for the public the resources that you provide to domestic workers through the Office of Wage and Hour.
Sure. And I'm going to ask both of them to introduce themselves because I can say
before they speak.
That's okay.
Yeah.
So before, I'll have Kenneth, you introduce yourself first, and then Dan, you next, and then you can take the first question.
All right.
Yes, good afternoon, Chairperson Bonds. Kenneth Walker, Deputy Director, Federal Workforce Programs at DOES.
Nice to see you again. Thank you.
Good afternoon, and thank you for the opportunity. I am Daniel King, Associate Director for the Office of Wage Hour. And actually, we do a lot of work with the domestic worker community. It's one of our strongest partnerships for the Office of Wage Hour. We have had several webinars with the community, partnering with several national organizations and local organizations to make sure they know about their rights. We've worked together to come up with frequently asked questions for rights, specifically for the agreements that domestic workers should receive from their employers. We've also had them participate in our Wage Theft Awareness Conference that we had last year. We actually had an exhibitor table from the local advocacy community to meet with them and provide information on site about the various resources that are available to them in the District of Columbia. That includes access to paid sick leave. That includes access to receiving a actual document from your employer that tells what your wages will be, how many hours you'll be working, and also getting all the rights of employees in the District of Columbia.
And I appreciate that. Thank you very much. If a individual is considering hiring a domestic worker, is there information that they must get from your agency before they do that? Or how do they learn what the requirements are?
Yeah, that's a great question. On our website, we have access to a full page for domestic workers with frequently asked questions, as well as templates for the hiring agreements that they should be, or the contracts they should be given to those workers. And there's information about what minimum wage is, how frequently they should be offering paid sick leave. And they, of course, can call our office or stop by our office to ask any further questions.
All right. And so if a potential employer does not follow your guidelines, are there some penalties?
Yes, specifically around the template for the contract agreement. If
Yes.
they are not following that, we ask the individuals to come forward and let us know so that we can engage that employer to educate them. But there also is a penalty for not providing the required contract document.
And I'm assuming the penalty is monetary.
Yes.
All right. So in the FY 25, how much penalty did you collect?
So overall, we collected over $200,000 in penalties.
I just want those numbers out there so people understand this is a very serious effort. And for the domestic workers to know that the government is the vessel that's being helpful to them. So.
And Councilmember Bonds, if I can say that I'm aware of the important policy issues surrounding domestic workers, how we have a lot of domestic workers that come from vulnerable populations, may not necessarily have the same level of education, maybe lawful citizens, but immigrants of this country. And so, we're conscious of the policy issues, the mistreatment that could exist. Daniel King and his team do a really outstanding job and have the ability to both support employers. So teaching employers about compliance, but then also teaching domestic workers about their rights as well. And they not only do that day in and day out, but I would say that they have some materials as well that they can share with both groups.
Thank you very much. Can we get a copy of those materials that you share with both groups?
Sure. Yes, we'll follow up after the hearing.
All right, thank you very much. Within 10 days, please. We'll put it on the list. Okay, thank you. In First Source, you said that you've created, this was very interesting, and I don't think the public understands. When we hear First Source, we immediately think construction. But your data is showing that the jobs in the city are really more non-construction jobs indirectly, because you're saying that for FY 25, that it created 1,049 jobs, 165 were construction and 884 non-construction. What are some of those non-construction categories of
Yep.
jobs?
So I'll start and then you can plug in, Dan. We're seeing an increasing number of IT related jobs. There are also some social service jobs. Those labor categories we continue to see increase.
Yeah, there's definitely an increase in IT companies that are looking for employees and staffing. We also saw a number of non-construction jobs in the hospitality industry.
Mm-hmm.
And then even in hotels, restaurants. So big bulk of them.
I think so. Yep.
So hotels and restaurants would be under the category of hospitality or separate?
Yeah, both will be hospitality.
Correct.
Okay. Thank you. That's really important to understand what our job market is in the district now. Thank you for that. We could talk a minute about paid family leave.
Okay.
Paid family leave, we thought it was going to be a hindrance in the business sector. It's ended up being a really bonanza in that we have the resources for the employee to reap benefits from their time and place. Do you foresee, as we did a couple of years ago, we reduced the amount of the, I guess I'll call it the premium that the business
Tax, yes,
paid.
ma'am.
Yes. Do you foresee that happening? Then we brought it back up to its natural level is what I call it. Do you foresee there being an increase or a decrease based on the usability, the frequency in which people are using it?
Yeah, so I shared some data in my testimony that I think, and now I'm going to try to go off of memory. I think the paid family leave program had 18,000 applications. They approved 90% of those applications. So one, in terms of usability of the benefit, it's there. You know it's there. And I'm going to get to the answer. I just want to kind of paint the picture for you. Then when we talk about revenue collection, and let's see if I've committed this to memory, I think we did about 147 or 8 million. Thank you. Let me see. Oh, did
Fits.
okay, the revenue collection number. So there's a bit of a structural imbalance right now in the PFL fund. It's not in the same place as the UI trust fund, which I constantly have to keep my thumb on the solvency of the UI trust fund because we're spending more than revenue that we're collecting. But any further adjustments to the PFL tax could create a very dangerous structural imbalance. If we don't take in enough money to pay for the benefits going out the door, it puts the fund in a projected deficit. And I think that's what we are seeing in terms of future trends, that as the benefit becomes more popular in use and the number of applications come up, if we're not generating enough revenue, we're gonna be in a position where we won't have enough, or that we'll reach our 6 or 9 month trigger, which is written into the statute, that would create us to cause us to either look at the benefit or put it on pause.
Thank you for that, because when we're talking dollars and cents in April with my colleagues, I wanted to be real clear as to where we are on this fund. Thank you very much for that.
And Councilmember Bonds, if I can just say, and I've warned against this, or warned council with this, is that there's a science and math behind trust fund solvency. At the Department of Employment Services, we run a very lean operation. There is not a lot of fat. We run a very lean operation. We have high capacity and high performing employees. The reason why the trust fund was able to reach the level of solvency and fund balance that it is because there's a phenomenal PFL team on the ground that understand data and trends and are able to collect. We have it's unique. Maybe not every agency does this, but if you have a fine in the unemployment insurance tax department, you can't move forward with PFL. We have tied collections and enforcement together. And so we have a strategy for collection, but we can't continue to spend without keeping in mind revenue and incoming revenue. So I would just caution folks to look and study the data to ensure what our safe zone is and that we don't find ourselves in a deficit.
Thank you for that. So are we considering, or do you see in coming years, months, that we may be at a point where we have to consider reduction in benefits?
I mean, I don't know if it's a reduction of benefits or a modification of the tax. But I would say my guess is end of FY 27, we would need to take a close look at both the outlays, which is benefit payments, and fund balance and tax. to make a decision what sort of intervention needs to be in place. I'm not convinced that it's one or the other. I think that there are opportunities to discuss all of the possible interventions that could be considered. But FY27 Q4, I think we need to take a look and be mindful of.
Thank you. And that's what we'll be discussing in April, May, and June. Thank you very much for that. There have been conversations here and about First Source just not fitting today's marketplace. And I wanted to get your take on that. I know you have in place a process, alternative plans. Can you help us understand what might be the focus as we move forward, particularly understanding now that it's not just construction? I think people are just waking up to understanding that.
So I think we have to understand at a 50,000 foot level that First Source is an economic development lever. It's a lever that we can pull to spur and ignite economic development. What I firmly believe is that if we can get businesses to continue to stay in the city or bring business and industry into the city, and they hire district residents, we will have people contributing to the tax base. We will have labor market participation. And so the theory of action behind First Source is not outdated. It is relevant for today. Now, we have some tools of innovation, is what I call them, in our toolbox that we can use. Alternative plans is one of them. What's important to me is that we have tools available to use when we need them. Now, I'm not supportive of folks trying to use alternative plans to circumvent hiring DC residents. That is not okay. But where it is okay is if we understand that there is a clear and transparent gap or lack of qualified talent in the labor pool that exists that would prevent a beneficiary from meeting compliance. That is when we take our tools of innovation and create both opportunity in the present, so that's actual jobs, and then we use it to build the talent pool. So that has been our thinking with First Source. Dan, you chime in if you think you have, if there's something else that I haven't shared.
Yeah, thank you. First Source is still important. We see that there is a lot of innovative approaches that we've taken that has created some pathways. And the director really laid it out perfectly. We want pathways to current jobs, and we want pathways to opportunities in the future. We want to keep that mindset because the workforce is always changing and opportunities are always changing. What we want to do at Workforce is make sure that we have a collaborative approach, and that when we are looking at projects that are coming to the district and district funds are being used, that it's being reinvested back to district residents as wages, as training opportunities, and then they become the taxpayers of the future as well.
And, you know, folks aren't really thinking about First Source in a way that is that contemplates all of the important levers of economic development. That's workforce development training, that's apprenticeship opportunity, that's incentives to business. I really push my team, and now we have these twice a month meetings where folks from across the entire agency, including First Source, talk about what we can do to get district residents to work and then support our economic development sister agencies by making sure that there's enough talent and that we're incentivizing business as well.
So when you mentioned your economic development sisters, are we speaking of like DMPED or just the government?
DSLBD, DMPED, let's see, the Department of Buildings, licensing, all of us are part of this economic development ecosystem.
All right, including the agencies that have their own workforce programming, I would assume, like DOE and others, yeah.
Yes, now we partner with DOEE. They've been a great partner to us on the GZEP environmental program through SYEP. I think we had like 400 or 500 kids last year. So we do, and then through the DC Infrastructure Academy, DOEE has also been a great partner. But a lot of those agencies we partner with currently.
Okay, and certainly with OSSI.
Oh, for sure.
Yeah.
Yes. No, for
Okay.
sure.
All right. There has been and continues to be some movement in community that believes that 14 to 24-year-olds are not receiving enough remittance, stipend, I'll call it a stipend, because it's not, really, they're not really salaried at the minimum wage level. Then, of course, the 9 to 13-year-olds, which are in your career ready program, they too are thinking, well, maybe we need a bigger stipend. In other words, I think because of our national economy and certainly inflation, et cetera, everyone thinks that we're not where we should be. Do you see, what do you hear from the young people in the program?
Yeah, and I get this question just as frequently as I get, how do I apply for SYP, or I need my kid in the CREST program. Certainly everybody is interested in receiving a higher wage. And I think within reason, it's okay to look at adjusting a bit upward. I think that's okay within reason. What I have the privilege and responsibility of doing is balancing the interest to increase the wage with creating as many opportunities for young people as possible. And if we increase the wage too much, then it cuts down on the number of slots that are available. In my testimony, I talked about over 3,000 applications in 48 hours, and I think we only have 350 slots. And so imagine
You mean remaining?
300, I'm sorry, that's for the CREST program. We have 350 slots
Right.
total this year.
Yeah.
And so if we rate in 3,000 applications in 48 hours, so if I raise the wage.
So the 3,000 was for the CREST program.
3,000 is just for CREST. We get about 18 to 19,000 annually for SYEP, and we have 13,000 slots. So if we raise the wage, it will cut down on the number of slots. And the reason why it's critically important, there's not an infinite amount of money available in government. My priorities at DOES are equally important to any other agency. And so I try to be very balanced when asking for more money. But with the resources we have, if I increase wages, it will decrease the number of slots that I have available for young people in the district.
All right, and I hear you. I'm just wondering also, and I have no idea of how this will work, just off the top of my head, wondering if some of our vendors, some of the organizations that hire or take on summer youth, if they were to have an additional stipend, if that would be something that we should consider, or if they added an extra level of training, almost like an internship, if that could be considered a way to get students that are in that program some higher remittance? And if we did that, would it create confusion because everyone will want to be where the money is better, so to speak, but you also have to go through that more rigorous training process?
Yeah, no, I think that's a great idea, and we actually do something similar now. In the past, our federal partners have paid an additional amount on wages. Now, in the last year or two, things have shifted a bit, and so we don't have the same amount of resources available to us from our federal partners. But we are currently open and supportive for any employer or business in the district that wants to bring on SYEP participants and supplement and add a little bit of the wage on top. We have the capacity and ability to do that, and we're supportive of that. So that's possible.
Okay. I was thinking some of these new developments might like to have their junior bid, so to speak, as an example. Because young people like to be out and around. They don't like to be, unless game board, or unless it's, IT. So just wondering if that were possible.
Sure. We have the capacity to do that, and we do it with and have done it with our federal partners for the last several years.
All right. Okay. Thank you for that.
Yeah.
Can you walk us through the current organizational structure of the agency? Because I count, 7 bureaus that federal programs, education and workforce, labor standards, state initiatives, economic stability and benefits, compliance, independent auditing, innovation and partnerships, and then I guess operations is another, so that's really 8.
Yep, that's 8. And then the chief of staff and the office of the director is another office, but not necessarily a bureau. When you throw in the general counsel's office, I think that might bring me to close to 10 direct.
Yes. Okay.
Yes.
And so are all of these positions current? That is, they exist and you have them individuals. The individuals on your chart are the ones who are in these positions.
I have one vacancy, and I have someone sitting in the role on an interim basis.
All right.
Mr. Mohammed Sheikh is, like I said, after 47 years, retiring this Friday. So that will create a vacancy, and we'll do a search for that position. So that will become open on Friday.
All right. So Daniel King is the Office of Wage Hours, so
correct,
would not automatically move to that level.
Well, nobody automatically moves anywhere. We run a competitive process, so they got to meet with the director.
The entire government does. I'm just wondering, Yeah.
No, I've not named an interim yet, and Mr. King, along with.
I wasn't trying to put you on the spot, Mr. King.
No pressure, Dan. No pressure. No, but I haven't named an interim yet, and there isn't an heir apparent that automatically assumes the.
Okay. I was just wondering if it's. I remember when I first began at the council having the opportunity a few years ago to come over and meet your managers, your really associate directors. So just wondered if I remember. I'm good at remembering the faces, so I was just wondering if they were some of your new. So
I'll tell you, any of my associate directors, are qualified to become a deputy, and I have trust and faith in them, like I do Dan King. Any of my deputy directors can stand in my shoes. And I have faith and confidence in them. And sometimes they all do. Sometimes we switch seats. They stand up for their deputies and stand up for the director. But, I put my team up against any agency in the district. I have the best team in the District of Columbia.
All right. And so, and well said. So you have vacancies. You have indicated to us you have vacancies. I'm not going to say how many because I know how the council behaves, so we're not even going to talk numbers. Okay, we're not going to talk numbers. But what I was curious about, some of these entities tend to, well, they look like they are a good number of vacancies, and I wondered, is that indicative of how they get their work done? Like education and workforce and economic stability and benefits, you have quite a few vacancies there.
Yeah, so on the education workforce team, a good number of those vacancies are seasonal hires for the Marion Barry Summer Youth Employment Program and MBYLI. We're only authorized to hire them at certain points of the year. They remain vacant during the rest of the year.
Thank you for that. Colleagues, you heard that. So when you see this organizational chart, it's seasonal, okay?
Yes, thank you.
All right.
And the reason why those positions are so critical, they're the folks that go in the field, make sure the place is safe for young people. They're out there all the time, dropping in on site. So those positions I need to function SYEP. On the economic stability chart, that's unemployment insurance and paid family leave. The bulk of those vacancies are in unemployment insurance. Those are fully federally funded positions. The federal funding continues to change and evolve. We now have, or we're in this era called defend to spend. And that's what they call it, defend to spend. And so we've not been funded in advance like we have in other years for unemployment insurance. And so it's unfortunate, but I have a lot of term employees that I'm only able to authorize funding and employment for them in 3-month increments, 4-month increments, because the funding isn't advanced to me and at the beginning of the fiscal year. So many of those vacancies exist there.
Let's talk a little bit about the unemployment insurance. I recall during COVID, there were a number of codes, errors, fraud, and we received, as most of the government, complaints, individuals waiting months, year to get a benefit. How are we doing with that now?
I'm so proud of this number. Wait, I have to reach back. What's the number of the backlog of claims? 26.
26?
Well, I had to ask the same question. I mean, I said, you mean 2,600? 2,060? It's 26. That's our backlog and unemployment insurance. And it's really to the credit of that unemployment insurance team. They're some of the hardest working people in district government, council member Bonds. I'm really proud of them, but they've exceeded my expectations. We're down to 26 in terms of our backlog.
All right, well, if it's not confidential, if we were to get their names, we'd like to make sure that they get a citation from the council.
Oh, that would be wonderful. Yes, and I think we've submitted the list of employees. Anyone who's marked UI is responsible for that, but we can reshare as well.
I think that would be the way to.
They work very hard.
I mean, because this was, those who are new, Mr. King, I'm telling you, it was a mess back in the day. I mean, I think it was maybe like 7,000. Am I correct?
Maybe a little higher.
Oh my goodness.
Might have been a little.
Yeah, it was 72,000. But anyway, it was unbelievable. And you wondered, how could an agency personnel get through that process? And that's what I think we want to commend, the fact that we got through it. And now we are like in the land of milk and honey, so to speak, where things are such improved.
Government employees don't always get a lot of kudos, but I'll tell you, the people at DOES have pride in their work. They take, and they've been there for years and they take pride in their work. They don't want to hear, that there's a backlog. And, I'm very proud of them, and they're probably watching, and I want to thank them because they've done a great job. I'm tough on them, but they rise to the occasion.
I appreciate that. I think a few years ago, I was able to commend a couple of crews from DPW. So yeah, so I appreciate our workforce. So
Yes.
we want to recognize them for
Thank
sure.
you.
Let us know. What measurable results did DOES achieve in FY25 and thus far in FY26, the first quarter, related to your stated strategic priorities such as service deliveries, operational improvements, and customer satisfaction? And how do those results compare to prior year performance?
Thank you for that question. The first thing I want to focus on is service delivery. And when you say service delivery, what it means to me is how many people got jobs? How many people did you service that got jobs? I included a data point in my testimony where I think I said, now I'm not going to remember, but the number of people, Kenneth, you may have to find it, of the number of people who were who visited the AJCs. In FY25, we served nearly 32,000 unique participants. We delivered over 77,000 career services. And the DC Infrastructure Academy in FY25, over 67% of people who successfully completed obtained a job. In our Title I WIOA programs, 59% of those people received employment. I mean, I'm very, very, very proud of the work that the team has done in service delivery to make sure wraparound services, follow-up, case management, job seeker assistance, all of those things come together to make sure that we're providing the service of making sure that people get employed. So that's one aspect of it. Additionally, on the, sorry, just give me 1 second here. Because Mr. Mohammed Sheikh reminded me this of yesterday, and I believed I mentioned it in my testimony. 100% of the claims that came in for private sector workers' compensation were responded to, and a decision made within 14 days. Councilmember Bonds, you can't find, I just say, and I love my folks from PERB and OLRCB, but I heard you say 7 years.
Yes, yes.
And so 14 days, 100% of the claims that came in, 14 days. And so that's some of the performance that we don't have an opportunity, to talk about. Over the last few fiscal years, did you know the Department of Employment Services returned back $35 million in a credit to private sector for workers' compensation taxes? We're in the top 5 in the country for the workers' compensation program. I can go on and on talking about the wins of the agency. Now, I always believe that we could do more. So I'm pushing the team to work on more jobs. We started out youth apprenticeship. I think we had 20. And I said, can you double that? Can you quadruple it? We're at 160 youth apprentice. That means 160 young people are in youth pre-apprenticeship, employer paid. So that's some of the success that we've had. We're not perfect, Councilmember Bonds, but we're trying hard to deliver the services in the best way we can.
All right, so you're telling me 160 individual youth are in apprenticeship programs.
Yep, and Kenneth, he'll speak to you about the youth apprenticeship.
How many different programs do we have?
Oh, we have a lot, Chairperson, and I'm glad to get in the game here. But for our youth, the program that the director was speaking about is our youth apprenticeship our youth pre-apprenticeship program. There's 160 young people that are going to be slated to enroll into those programs through the end of this fiscal year. That also pairs with our in-school youth apprenticeship program as well. So that's the program that we currently have at 21 different public charter and high schools right now that serve 60 participants. And then young people also eligible for our apprenticeship system in general as well. You know, we try to promote these pathways to district residents as well. And in FY26 Q1, those programs in totality serve 925 district residents. No problem. I get it too.
But I'm getting through it and you're getting through it. So thank you for that and being patient with me.
I had the Benadryl this morning, so
Oh.
so we're here.
And I would be asleep here on the dais if I did that, but thank you very much for understanding. You mentioned 925 that were.
Yeah, 925 active apprentices that are DC residents. So that is inclusive of youth as well as our adult population as well. So that's the construct of our.
So I subtract 160 from 925 to get the adult population, basically.
You could look at it that way. So pre-apprenticeship was the slots that the director just spoke about. So this is the program that pipelines young people into apprenticeship programs. So they're not necessarily in that 925 count yet. Yep.
So only 60 in school are in this pipeline. So I would subtract 60 from 925 then?
60, that is correct, because those are youth.
All right, so I got the right number.
There you go.
Okay, great.
Yes. Mm-hmm.
Okay. For our adult apprenticeship programs, how are we doing? Are we finding that our programs that are how long are these apprenticeship programs?
At minimum 1 year, and at its maximum, it's 5 years in length.
Okay. So when you're in a program for 5 years, during that time, you're paid.
Yes.
During that time, you're learning new skills.
And paid at a progressive wage, though. So you just don't start at the same wage. It goes up progressively as you take on your on-the-job training, RTI, in advance within the program.
And how many survive the programs? That is, how many enroll, go through the apprenticeship, and come out whole so that they have the skill set and they are bona fide, I would guess, union members?
Mm-hmm. I mean, that's the magic of apprenticeship. Nationally, the metric is 91%, and the district rivals that we're right at about 88, 89%.
Okay.
So it is a high success rate. So that's one of the biggest benefits we're able to tout to employers about the apprenticeship system.
So our apprenticeship programs are more than 50% of the programs requiring 5 years apprenticeship, or are they more on the side of requiring 1 year apprenticeship?
We can get that breakout. So I'm getting you some accurate information.
We would like to know what it is.
Yeah.
And also by occupational category and maybe industry.
Yeah.
For instance, yes, it is those who do customer service, but it's also the technical staff. It's also those that do IT jobs, so we can get a sense of what seems to be flowing, because we always hear from the industry, the commercial side of DC that says, oh, we have these jobs. And years past, they have said, well, it's hard to get a qualified DC resident in these jobs. But, you and I know that there are some categories that they are filling with DC residents. And so just trying to understand what the trends seem to be so that we can be better as a government and advocating for the types of workforce training we need to do. Like today, we heard that arbitrators it's something that's needed. And so I'm looking at the different aspects of regular life in DC and how do we get our young people and current adults that are looking for jobs into these occupations? What real training must they get? And in many instances, it doesn't require what you and I maybe went through 4 years, 6 years. It's short circuited now. And there are new ways of teaching. So wondered what we can do to get more of our residents in jobs.
Yeah, and you're asking the right questions, council member. And, I heard the director extend kudos to the amazing UI team that we have, but our apprenticeship team is equally as amazing, and they have a lot of great relationships with our registered apprenticeship sponsors. So, we speak to them in real time about program design. We have to, on an annual basis, do like performance visits and, monitoring and compliance visits where we talk about the construct of the program. We talk about their apprenticeship standards. We talk about success rates. And basically what we want to get to is like, what is our quickest and most efficient track to get district residents where they need to be? So, we are happy in that work and we're very prideful in that work. So some of the follow-ups you mentioned about the year commitment, whether it's 1 year or 5 years, we can provide. But I do know that as part of our pre-materials, we did submit a list of like all apprenticeship programs that are very
Yes, you did.
by sponsor, but we can add that extra element that you asked for.
The audience, those at home to see, I have a notebook like this, literally. I think there are 151 attachments. I just want the public to know, okay, and this is representative of the work of the agency, and that's the important part. So thank you very much for that. It's a little heavy on the shoulder, but thank you very much for that. That's all right. No, I have actually received some work from agencies where it's been in 2 binders, but no, I'm not complaining. I'm just simply saying to the public, it's the real deal. So that's what I wanted them to understand. How do you coordinate with the adult charter schools like Carlos Rosario, where they have a wait list of, on any day, about 2,000?
Yeah, I'm actually glad you asked that question because I was at that hearing that you participated in, Chairperson Bonds, and we took that as a moment to like increase collaboration with our adult education providers. So immediately after that, what we heard a lot in like the testimony that was offered is that these adult education providers wanted more insight in terms of like labor market information on where to gear and steer their program. So immediately from that hearing, we held a capacity building session where we offered invite to all adult education practitioners to kind of get to understand the information that we see. These are the hot jobs. This is where industry is expanding. This is going to be the pipeline towards employment. And we were very happy with the result of those things too. We have also extended conversation around, back to one of your favorite terms, apprenticeship. A lot of individuals are endeavoring into the apprenticeship and pre-apprenticeship work. So we are active in current conversations with certain adult education providers to talk about like, how do they enhance their program? How do they augment it? Could the pursuit of registered apprenticeship standards be something that is beneficial to them? And these entities would also be eligible for some of the things that we're thinking about around contracts and future programs that we're iterating right now. So we went to immediate work to strengthen some of those relationships. So we were excited that that's a result of that last hearing.
I am excited that you mentioned that because it seems to me one of the missing ingredients is the work that your agency can do to create some standards for the different types of training because so frequently individuals will say, well, I've been trained in this, that, or the other, but I still haven't gotten a job. And when we check with employers, they're like, "Mm-mm." They didn't seem to have that kind of skill when they came to our office.
And further, it also provides an opportunity for, partnerships in ways that we really haven't seen. We were just in conversation with Academy of Hope last week, for example, where we spoke about, some of the recruitment efforts that they put out there and, getting this wider range of district residents involved in their program. So what we discussed was like, hey, come out to the American Job Center. We have this footprint where we've seen, 34,000 people come through those doors across a program year. Let us do some of that work alongside you all, right? Let's iterate some of these programs together. Let us leverage some of the best practices that we've seen in this adult workforce education work. And, those are relationships we seek and desire with our adult education system. So we're starting to see a couple of those tea leaves begin to drop, and it's exciting.
I also think, Councilmember Bonds, it's perfect timing, given what's happening on the federal state, where OCTE, the Office of Career and Technical Education at the Department of Education, is moving over to the Department of Labor. And I understand by the end of this summer, I don't think a TEGL's come out yet, but that eligible training providers will be able to use Pell funding for training in adult education. And so this is the way that we have to begin to strategize and think. How are we going to connect adult public charter schools and adult education to workforce development training? But the time is here, and they say end of June is we'll be able to start using that Pell funding.
I appreciate that and wonder if you have begun the process of drafting legislation so that it's very clear that we have some standards in place and there is a process that you are expected to follow so that your enrollees go through a certification process so that we know what we are putting out. I must tell you, I've been to a few training programs where it left a lot to be desired.
Yeah.
But nevertheless, they were funded to do training. Again, there's the other side too, trying to get enrollees in some of these programs. We need a tremendous amount of incentive for some people to want to go through a training program. Frequently, they don't know what is really expected of them. They don't know how easy it can be if you follow along. And then, of course, we have the issue of literacy, just basic literacy so that you feel confident that you can compete, that you can write your name. I mean, something as simple as that. So I'm just wondering about when we talk about workforce, we're always talking about the industries and the need, like I just mentioned, arbitrators, but we really also have to figure out how do we get people who are unemployed, who want to be employed, into an occupational or career line.
Yeah, I mean, when I talk about the labor market and labor market participation, I often describe those that are unemployed in different subgroups of the unemployed category. You have those that have been recently released from work, and there's a reasonable expectation that they'll return to the labor market. You have people who are chronically unemployed. That means they're cycling in and out of the labor market. You have people who are chronically underemployed. employed. They've taken a job, they continue to take jobs, not necessarily long-term, might be seasonal, but don't necessarily fit their aptitude and what they can do. And then we have long-term unemployed, may have done bouts of incarceration and substance abuse. And my thought is that we approach each of these subgroups of the labor market population in a different way, but using the same model. That's why I love, and see, this is what happens when you commend one group and you don't say all the groups. Mr. Brown, you know Mr. Brown from apprenticeship.
I do.
He would want us, Councilmember Bonds, you and I, to say and talk about the Step Up program with unions. Those are folks who want to work. We know they have the aptitude. We know they have the skills, but they need a step up before we put them right in. Our division of state initiatives and all of the folks, Mr. Lewis, Miss Lewis, all of the folks that are down there, for our family and folks that are returning home, they need something a little more. They need assistance with reintegrating back into society and more emphasis on those soft and essential skills. So we want to help everyone. There is a way to help everyone. I have a similar model. It's just our approach to how we serve them is different.
Well, as I told the other directors, I'm not going to ask you about your enhancement paper, but I am going to ask you if we are serious about getting these underemployed individuals into the workforce, please let me know so that I can go to battle. I can't battle for something that I don't know about.
Understood.
And it doesn't always have to be dollars and cents.
Mm-hmm.
It can also be maybe a structural issue. Let's see if we can make this system work even better, and particularly for those that know that they are left out.
Mm-hmm.
Yet they're on our streets every day, and we see them and they see us, and they wonder why we have and they don't have, and you know what happens then. So I'm just trying to figure out how we can utilize the resources we have, and then where we just do maybe a little addition to a resource, it'll make a big difference. And maybe we do some of this with the public-private partnership approach. It doesn't always have to be, because we don't have a lot of resources, but we have some. And maybe we look at internally at resources we have, and maybe they need to be, wiggled over to another part. I know we don't have a lot of time because we have budget coming up, but there are some things I do believe we can do. And I'm most concerned about how do we guarantee that a lion's share of these 16,000 jobs that are coming online, supposedly from the RFK campus, will be opportunities for DC residents.
Yes. Yeah.
I mean, we really got to push on that.
I was going to say, I think that's where we don't have to talk dollars and cents, but we can talk opportunity and proven practice.
Yes.
And, I over the last 10 years have been pushing high quality programming. It's lost me some friends and it's gained me some new ones, some new allies. But where we have opportunity is RFK. Where we have opportunity is, Capital One, and Capital One I think is going very well. Dan will tell you about Capital One. We have other development projects that are coming online where I think that there are opportunity where there's proven practice. I mean, like actual jobs, DC residents and jobs that I can count and verify. We know pre-apprenticeship. We know formal apprenticeship is where we have proven best practice. So, these two guys are the experts. Dan, maybe, you can talk a little bit about Capital One and our strategy around RFK.
Yes, that would be great. And also help me understand about new apprenticeships that we might need to create, because businesses tend to like that. Then they feel like they get a person, they get to groom them their way, and they get to see their performance. Because remember, one of our biggest hurdles in the district is that we for so long have been perceived as not being up to a standard. And therefore we could be dismissed because we're in this region. And the region is full of talent, but not here in DC. So how do we transcend that is what I'm concerned.
So Dan, why don't you take Capital One, and then Kenneth, why don't you take the question on new apprenticeship and emerging innovation there?
Certainly, we've seen great work at Capital One and great partnership and collaboration of all the parties, the beneficiaries, the general contractors, and the OES. We're making sure that small businesses as well as larger contractors are working, that are DC businesses and have DC residents. We saw through the demolition parts of the construction that they've met the compliance goals, and they are trending still in that direction today. There is a percentage goal of 35% that they have been able to surpass so far on the construction that they're doing at Capital One. And they're still trending towards 51% of their new hires being from district residents at the Capital One project now. And we're looking to see the same thing at RFK. We had several opportunities to connect with the business industry and those that are interested in the RFK project. There was a recent convening on this past Monday at UDC with Chamber of Commerce, and I was down there. I got a chance to meet with several different contractors that are looking for opportunities. And we want them to know, like, hey, we want you here in the district working, but we also want you to bring on district residents when you do so.
I appreciate hearing that, but how do you know that this is really going on? I know you're not out doing the inspections. You must have a team of people that do that. But is your team there on the job just checking to see what's going on? I mean, that's what the public wants to know. They accuse us of, being in the ivory tower where, we pontificate and, have all these forms and what have you, but we're not there where the action is.
Yeah, they're not talking about my first source team.
Okay.
We have
all right.
boots on the ground, hardest working team within the district government, I believe. You've heard about all the contracts that we oversee every year. A small group, but we're mighty. And they're going to go on site. They're going to meet with the contractors, and then we're going to have convenings. We're going to do periodic monitoring reports to let them know where they are in their compliance. And then we're going to collaborate them with other parts of the OES. We're going to bring in our Office of Talent and Client Services once we find out that there are new opportunities that they need to hire for on that construction site. And they're going to do some recruiting. They're going to do some preparing. We're going to look for individuals who've come through the programs at DOES or through other partners for pre-apprenticeship or even for job readiness at some of the lower levels of that, like the common labor work that we're always looking to bring DC residents in. But we know that a lot of the wages are being earned from the journey worker trades. We've done great over the last few years of building up a pipeline so that we have DC residents that are already being employed either through the unions or through the contractors that are winning bids. And then we have new hires that are available to be employed. So it's been a win. And those are the positions that DC residents are making the most amount of money. And we're seeing that's where the most amount of the hours are being worked. So it's a great positive for the District of Columbia.
And then
So
further,
how many staff do you have that are
14.
14? And this is Office of Wage Hour?
That's the Office of First Source Compliance.
Okay, First Source Compliance. So how much money has been collected was collected in FY25?
FY25, we collected just over 500,000 for First Source, either penalties or contributions through alternative plans.
All right. Okay, thank you. Sorry, Mr. Walker.
Oh, no, it's all as well. But no, I just got to follow up on your question. Like, how do we know the work is going on? When
Yeah.
some of these positions convert to apprenticeship positions, that does mean that they are then subject to our compliance and monitoring function. So, on a quarterly basis, we review wage records of these individuals, like to ensure that, wages are paid, or if a prevailing wage is necessary on these jobs, or if a progressive wage needs to happen. So we do have those mechanisms in place to ensure that those are going on as well. And then additionally, with apprenticeship, there are very specific requirements in a apprenticeship standard and work processes that these employers are responsible for. 2,000 hours of on-the-job training, 144 hours of related technical instruction, and that is all tracked. They have to provide that information into our Apprenticescope system, so in real time we can understand what is the progress of our apprentice.
Okay, you do the federal programs, right?
Yes.
So you're speaking of the youth apprentice programs.
Correct. It's a few different things. I oversee our American Job Centers,
Yes,
our
yes.
Office of Apprenticeship Information and Training, and our Office of Out-of-School Youth.
All right. And so the apprentice program for adults is different. Do you also oversee that?
Correct.
They're not federal programs, correct?
They are not federal.
They're local.
Yeah. Mhm.
So you're state initiatives too, huh?
I am not.
Okay. I'm just trying to follow the chart.
I got it. I understand.
Okay, so how many adult apprentices did we have? I think you,
Adult apprentices, active registered apprentices, end of FY26 Q1 was 7,395.
okay, these are individuals and they are working at how many different locations?
We have our registered number is 317 active registered apprenticeship programs in the district.
Okay. And are most construction or
Yeah,
non-construction?
most are what we consider traditional trades, so in our construction skills trade. But I will say, year over year, the last 3 years, we've seen the non-traditional lever uptick a little bit. A lot of people are starting to identify. If I were talking about like current concentration, we're at about 80-20 right now.
All right.
Yeah.
I think I had the occasion to talk to you about one of the IT companies, and their issue was they had gathered all of the paperwork and the registration, and I think they were not aware that to participate in the program, the registrants had another registration, which was the federal registration they needed to complete. Why don't we just have them do the federal registration? Then they're in the federal and they're in the local program.
Yeah, that is an active conversation we're having with Department of Labor, ETA.
Okay.
We are seeking reciprocity, so that we have a reciprocity task force in partnership with the WIC to focus on some of these things. Let me actually take that back. That was specific to ETPL. We've been working directly with Department of Labor on reciprocity for national approval of apprenticeship standards here locally. So,
All right, excellent. So you're gonna have something ready before September 30th, hopefully,
they have.
if this administration
They have a few new
allows it.
players,
Yes.
so we're working on it, but it is something that is very important to us because what we're trying not to do is to create, so many different pathways where it feels, overwhelming to our
Yeah.
apprenticeship sponsors. So
Yeah, I've actually heard from some of the vendors that have a workforce contract to train, let's say, 60 people.
mhm.
And they get their contract in, let's say, December, January. And they do not get all their registrants for the program until March because they feel they have to go through this complicated dual registration process. But their contract might end September 30th or even earlier, depending on the flow of money. So what's going on there? Could we get more unification in our process?
I'm not sure how common it is that a registered apprenticeship sponsor needs to also be registered for the federal program at the same time. Is that pretty common?
It is not, yeah.
So we might need to look at the registered apprenticeship sponsors / companies that are raising this, because this sounds to me to be like a one-off and a unique set of circumstances. I would need to understand why they need to do both
Yeah.
federal and local. If maybe it's the type of project they're working on where it's
Yeah.
funded with federal and local dollars. I don't.
When the chairperson mentioned a contract, I would imagine that these might be federal recipients that
Okay.
are now trying to do work in
In the district,
Yeah.
perhaps.
Yeah.
So,
Yeah.
if you offline can connect us to maybe who has raised some concerns, let us work with them to try to navigate this and assist them.
Definitely, definitely. And then there was a concern last year, I don't know if we've resolved it, and that is with these local security companies where the certification goes to the company and not to the individual that goes through the training. And wondered if we can really fix that. Because if I go through the training for security personnel, I would like to think that my certification can be used wherever I go. In other words, I don't have to stay with ABC. I can go with NBC, Q, whatever it is. In other words, it's right now, it should not be, in my opinion, attached to a company that provides, I guess the company provides the insurance. Maybe that's how they get away with this, but I don't know.
I would love in this last year if I could work with licensing on licensing reform on occupations, because there is opportunity with security guards. We've heard it time and time again from Allied Barton about the process to get people licensed. We were at the WIC meeting.
Yes,
And they brought it up. Maybe that's something we can work on together to try to create a more seamless process and get folks licensed. So maybe we can put that
Yeah.
on our list and see if we can come up with a solution.
I agree, and thank you for that, because it seems like it's so unfair. I go through the training, but then my training is no good unless I can take that training certificate to an organization that actually, is a vending company. That's what it is. So it's almost like being, what is it, that we once had in this country? Where you worked the farm, but you didn't get a chance to own the farm, but you worked the farm. I mean, you all are too young to even know anything about it, but it's certainly sharecropper.
Yeah.
Yeah, that's what it sounds like.
Yes.
Yes, that kind of relationship.
Why don't we work together and let's see if we can come up with a solution so we can put a better system in place.
All right, thanks a lot. Thank you very much for that. What is the status of the American Job Centers now? I know we had a little turmoil a few years ago.
Well, I don't know if I'd say it's turmoil. I mean, I think the American Job Centers serve its purpose, which is supposed to be a one-stop operation for our federal programs, both workforce and unemployment insurance. But we've seen some wins lately, and we've staffed and structured it a bit different. Kenneth, do you want to talk to the American Job Center?
Yeah, no, it's an exciting body of our work, person. And, I think in our last week, we now have 3 American Job Center sites here, 2 of which were new. I believe that was FY 24 into 25. So we're at 899 North Capitol Street. We're right there at Shannon Place by the big chair. And of course, we have our comprehensive job center at HQ. We've really had to be in a flexible space this year with some of the things that are going down federally with the shutdown and the furloughs and the rifts that we've been experiencing. So we've elevated our service delivery model. One piece of that is introducing artificial intelligence through our Skills Nation platform. We wanted to provide a different way to do intake assessments, assessing for skills, supporting residents with developing skills-based resumes, putting them in a place where they're able to identify personalized tracks based on what they're interested in. So we now have a very technological approach to what we do in our American Job Center. We're also piloting what we call WIOA Go. WIOA Go being the federal enrollment process for individuals to get connected to Workforce Innovation Opportunity Act dollars that provide a line of training and all these different things. One thing that the director has really pushed us on is that WIOA eligibility could take, days, weeks even, right? We've now leveraged artificial intelligence as well to speed up that timeline. How quickly can we get district residents into WIOA so that we can serve them? And, that's something that, like I said, we're piloting right now. And, we hope to continue to progress that. And there's already some national attention on what we're doing around WIOA Go. So that's an exciting innovation that we're looking to do. But more than that, we're just trying to create a lot of energy around our American Job Center system. I've been pushing the team to really think through an in-person workshop delivery schedule, to get the workforce on wheels in a place where we have a consistent schedule across the city. We're at libraries, we're in communities doing the work. And the team has really grasped on to the new energy and vision of what we want to see. And I'm very excited about what the American Job Center is doing and will do in the future.
So are you telling me that you have a mobile unit that roams around and people can fill out all kinds of applications, see the postings of job opportunities?
Yep, they can come in.
So finally, we're back to an old system that worked in the past. I've been here long enough to know that it really did work. And community felt like we cared, bringing it to us. We're not on the metro system, line, so to speak. The bus takes forever, all of those kinds of arguments that we heard. So thank you for getting that done, and much success with that, bringing that old innovation back. Really appreciate it. Do you keep records? I know you must, of formerly federal employees that have been hired in DC government.
No, of former federal employees hired in DC government.
I'm thinking about those that lost their job and
I see.
recruiting, trying to get them situated.
No, I mean, that's probably the personnel authority. DCHR is my guess. DOES does not.
Okay, I just wonder. Well, yeah. DCHR doesn't either. They're in our committee, so we've been searching, trying to understand what's the volume, how useful has the recruiting been, trying to understand that. Okay.
I mean, let me think if the data that we have might yield some sort of analysis. Let me think about that.
Okay.
It's not a running list and report
Right.
that we have on hand, but let me think if that's possible.
Yeah, I thought it would be useful to know what kind of federal burden we're taking on. Although we're a federal entity, but still, we're helping.
I mean, we might be able to create a report, but let me think through it. And if it's something that's in the realm of possibility, I don't mind providing that sort of analysis.
All right, thank you very much. The Comprehensive Adult Student Assessment System, CASAS, as you know, the exam measures reading and math skills needed for workplace and real world functioning. And given that 451 individuals tested below the 8th grade level in reading, and 1,314 below 8th grade in math in FY 25 through the first quarter of 26. What targeted interventions are in place to help these individuals?
Good question. Over the years, I've tried to strike the balance of making sure we provide workforce readiness and occupational skills, but that we also support those that we now or have been identified as having a potential barrier academically. And so one, I think our strongest ally and partner there is OSSI, where through their IENT, Integrated Education and Training Program, a DC resident can go through both academic training and occupational training and then earn a wage at the same time. I think that's probably our best example of how we support those DC residents. Although many of us, 2 of the 3 on this panel, are what I call educators in recovery. We've served some point of in our career in the K-12 system. In terms of our infrastructure at the Department of Employment Services, we're not necessarily set up to provide academic training. So I'd say OSSI is probably our strongest ally and partner there. Is there something, Kenneth, you might want to add?
Yeah, and I would also say out of this subset might be representative of our out-of-school youth individuals too. So if that's federally funded, even though we call it youth, that is between the ages of 16 and 24, any training provider that we bring in with that federal dollar does have what we call it 14 required elements. And youth educational attainment, learning loss, some of that things is one of those things that they have to focus on. So that passes along to the training provider that also has to be able to provide that service if a young person needs that, if that number includes some of that population as a subset.
I guess I was wondering, since we hear so frequently that literacy is a major issue, to job attainment, I wondered if there's something that we do in the summer employment program that could sort of do an uplift, maybe an orientation. I don't know if but it just seems to me you got to capture the audience, an audience that wants to earn, wants to have the stipend. I don't know.
Yeah.
There'll be another,
Maybe
maybe that's an extra 3 days of, preparation, stipend time or something. I don't know.
might be in the realm of possibility.
All right. Just trying to figure out how we can get as much more done as possible. What protocols do you use to vet and approve training providers?
Yeah, Kenneth, I'm going to start here and then I'll let you jump in. What's critically important to me is, in terms of standards, is the performance of a training provider. We look at past performance, how many people enrolled, successfully completed, how many of them got jobs, same standards that I apply to our internal programs here at the Department of Employment Services. I also look at quality of the programming. To what extent are participants learning? What is the quality and the rigor of the material that's being presented? Is the material that's being presented in line with industry standards? That's some of the criteria and standards that we use to make a determination on training providers. Kenneth?
Yeah, and on top of what the director just mentioned as well, in our recent grant making, we've also made it a requirement, at least with the workforce programs, that the applicant be able to show evidence of employer-based relationship, right? Not just in name, but formal relationship connection. At the end of the day, we want to make sure that we get employment from these training providers. So that's something that we have implemented and put as part of our rubric. I would also say that we also do site visits for all grantees as well, whether this is through notice of grant agreement or if this is through our procurement process in partnership with OCP. We want to see the site. We want to feel the site. We want to understand where, individuals are going for training. So that's also part of our evaluation as well.
Thank you very much. I appreciate hearing that. I actually have had the occasion to, as I mentioned, visit some sites and wondered, a lot about that. Help me understand your statement about relationship. What does, help me understand what that really means?
Yeah, but at the end of the day, we want to make sure that the providers that are coming to us, if they have a requirement performance-wise to achieve employment, we want to understand, what that plan towards employment is. Like if they say, we're doing carpentry training and we have connections with the carpenters union, we want to see some sort of evidence of that, right? We want to be at a place where we know going into the program that we have a training provider that is capable of achieving employment. So that's the hints of where we try to see a little bit more about the context of the relationship and, how far along are they in that relationship? Is this somebody that they have been working with? Is this hypothetical or real? So we begin to ask some questions around that piece because this is all wrapped up into performance.
All right, so that's very helpful. So it may be a vendor that is brand new, full of ideas. Maybe they do not have a track record of working with an organization, but because of the rigor of their materials and because of the quality of the program as you have evaluated it, and the number of individuals that have already want to be a part, they haven't quite enrolled, but there's that kind of interest that would cause you to say this is a program that we should at least fund on a pilot basis.
Oh, yeah, and we've done pilot programs at DOES. I mean, at the end of the day, our training providers' performance is our performance. So we're partners in this work. So we see, off the merits of a proposal, a strong thought out idea. It might be a hypothesis, it might be something that's piloted, but it's innovative. It's something that district residents want. The director has been very supportive of us, pursuing those opportunities and us working with that training provider in partnership. I don't want any of our training providers to feel like they're siloed. They're responsible for their work. So I'm all in. I love innovation. I love new ideas. And, when training providers bring something like a new idea, we want to explore it.
And so how hard is it to tell a provider that they're no longer in or under the tent because their achievement has been, faltering?
How hard is it for us or for them?
It's for the agency, of course.
No, I mean, I could see, folks taking the position that it might be difficult to share with a training provider who's been with us for a while that their performance is not well. But I remind staff that they have a responsibility, which is to provide high quality training that leads to a job and an industry and a career. And so at hard as it may be for the person who's receiving funding from us to hear that their programs are not cutting mustard, to me, I would think it'd be harder for the individual employee knowing that it's a reflection of the performance of their work. And my staff understand from me and at least my senior staff, we shouldn't let things get in the way of our day-to-day responsibility because that would present ourselves being in a very hard and difficult situation. So I don't find it to be as difficult on our side, but maybe for the person receiving the news, it may be difficult for them. Mm-hmm.
I'm sorry, I thought it was on. Okay. Now that the Infrastructure Academy is opening this year, what types of jobs and career pathways will participants have an opportunity to encounter at that
Yeah.
institution?
I'm very excited about this. DC residents will have an opportunity to receive training that could lead to a career in automotive, like engineering and maintenance, which I'm very excited about. I envision a world where DCIA graduates are able to work for District of Columbia government agencies and repair vehicles in our fleet. DC has a pretty sizable fleet with DPW and DDOT. So I think that there's a world where that could exist. Also, our PEPCO, Washington Gas, utility training programs, even our partners at DC Water, like common labor type of training exists. We'll still maintain an IT infrastructure training program that won't go away, but the automotive engineering piece is really big. Adults will be able to go to basically technical school, which does not exist here, like technical community college or technical post-secondary programs, which doesn't exist for adults here in the District of Columbia.
Thank you for that. Big question. Okay. Will I be able to drive my car in and have the students that are there to work on my car, much like, you can go to Howard's Dental School and as the seniors tell me, they hook you up. Okay. So I'm just wondering.
Not yet. Not yet. We need to get the program stood up first. And we need to make sure that we're training people that are credentialed and skilled to do that sort of work. So that's not yet. That might be a few years away. But I understand, just like beauty school, you can go to beauty college and get your hair colored. I get it. Not today, but there might be a world in which that's possible.
All right, for those listening in, you'll know that you've got to wait a little bit. You still have to go to Jiffy Lube,
You still got to go to
like that,
Jiffy
for a
Lube.
while. But it has the potential of coming. That would be great.
Mhm.
Can you please explain how your subsidized work experience program operates? How you bring in employers, how the wage subsidies are handled, and how you track whether participants move into unsubsidized jobs?
Yep, great question. The subsidized employment is also known as WEX. It's a workforce experience. That's what it's short for, an abbreviation for. The way it goes is that after a participant successfully completes the portion of training where they're ready for paid, ready to go into workplace work experience where they can get an actual experience and the job and career they're being trained for. They received an hourly stipend in which they are paid every 2 weeks by the Department of Employment Services. Those WEX programs can go anywhere from 6 weeks to, I think it could go as long as maybe 12 to 14 weeks. The way in which we partner with industry and employers is a few different ways. Each of our programs have really strong relationships and partners with industry. And so they will leverage those partnerships to work with employers and offer them talent who've completed the program that they could work at no cost in their businesses. We also partner with First Source and have a list of First Source employers and opportunities that could exist there. So that's another pipeline. Our Office of Talent and Client Services also work with business and industry to bring in new employer partners. Everybody is a job developer at DOES. I'd like to thank Councilmember Bond, since you've taken over this committee, even you're a job developer. Think of the businesses and unions that have come and said, hey, we have so many openings. Can you help us?
Yeah.
You know, so everyone's a job developer. Everyone is bringing partners to the table. We're connecting people who complete training successfully and are credentialed to work in those experiences. And they can last anywhere from 6 to maybe 12 or 14 weeks.
All right, thank you. I actually have a few more questions, but I think if you would allow me, I think I'm gonna take my leave. It's a problem, so if you
Understood.
don't mind, and we may have to send you a little note on these others, but thank you very, very much
Thank you.
for today. You've been very generous with your time, and we appreciate the time that you've spent with us today.
Thank you, Councilmember.
Thank you very, very much. I thank everyone who participated in today's performance oversight hearing and for their contributions. As we've learned, these agencies before us play vital roles in the district's workforce, labor relations, and government operations. If the public has any additional thoughts or would like to submit written testimony regarding the performance of these agencies, please upload it to the hearing management system at dccouncil.gov or email it to seal@dccouncil.gov, and that's CEAL. The hearing record will close on the 12th of March at 5 p.m. So please submit written testimony before that date so it can be entered into the public record. The next performance oversight hearing for the committee will be on Monday, March 2nd at 9:30 a.m. And we will hear from the Executive Office of the Mayor, the Mayor's Office of Community Affairs, the Office of Senior Advisor, and the Office of Inspector General, and Destination DC. And with that, this concludes today's hearing, and the time is 2:23 p.m. on Thursday, the 26th, 2026, same day in which we started, and the meeting is adjourned. Thank you.